Good morning and welcome. We will call this hearing back to order. First thing we'll do, as we do in all our virtual hearings, is the roll call for the commissioners. Commissioners, if you will just answer. Vice Chair Belser.
Present.
Commissioner Whitfield.
Here.
Commissioner Hamilton.
Here.
Commissioner Howard.
Here.
Commissioner Irvin.
Here.
Commissioner Williams is serving our country in Iraq, and Commissioner Randall is here. I think, let's see, we've got at least one or two preliminary things. I'm going to call on Commissioner Belser first. She had asked for a late file exhibit yesterday, so Commissioner Belser.
Thank you, Mr. Chairman. Mr. Chairman, I would like to thank Mr. Hafer and Mr. Dade for Palmetto Utilities for providing this as quickly as they did. That's greatly appreciated and noted. Thank you very much. I believe yesterday that I'd asked that a hearing exhibit be marked for identification and reserved for this exhibit, and I think it would be appropriate at this time to ask that this later filed exhibit be entered into the record. I know it's a little bit unusual, but provided there's no objection from any of the parties.
Yes, Mr. Hafer.
I am delighted to make the motion to move the as hearing exhibit 7, the document that I electronically filed with the commission this morning, and that's one of two housekeeping matters I needed to take up. So through the chair, I would thank Commissioner Belser for raising the first one, and I would move that into the record as the hearing exhibit 7. It
will be entered into the record as hearing exhibit number 7. Okay, Mr. Hafer, continue.
Yes, thank you, Mr. Chairman. The second housekeeping matter I need to take up is just to clarify for the commission briefly when the company believes a usage-sensitive rate could be implemented. Commissioner Belser had some questions yesterday about that. And I wanted to clarify that the company agrees with Commissioner Belser's reading. A usage-sensitive rate would involve the company seeking to cover additional revenue, and thus it couldn't happen until 2023 under the stipulation. So we agree with Commissioner Belser's premise yesterday. I'd also note that the statute that governs commission proceedings for increases, 58-5240G, that would require a rate case in order to implement those increases associated with going to a usage-sensitive rate. But the company can and is willing to do a feasibility study and a cost of service study in advance of that, in advance of the next rate case. I would also note that I believe Mr. Dade testified that as a practical matter, we're not going to have the City of Columbia automated meter reading data before 2023. So I just wanted to provide that clarification this morning before we proceeded with the rest of the company's case in chief.
Great. Thank you, Mr. Hafer. I appreciate that. That gives us some clarity on all those issues. Okay. Anything else preliminarily that we need to do today before we begin? Any of the parties?
Mr. Chairman, this is Roger Hall, and it's just a...
yes, sir, Mr. Hall.
I'm unable to see the commission or anybody other than the participants at this time. I'm sure it's my fault, but...
That's probably a blessing for you.
I just want to make sure everyone else can see them, and it's just uniquely to me.
I cannot see them either, Mr. Chairman.
Yeah, right now, the only people on are you folks are on the screen. Okay. So I'm sure it'll come back to us, and you'll get that joy in a little while.
Well, we appreciate it. Looking forward to it.
Okay, great.
Thank you.
All right, so I believe we are, Mr. Hafer, the ball's in your court with your next witness. I believe it's Mr. Walker.
Thank you, Mr. Chairman. Yes, that's correct. The applicant we call Harold Walker.
Okay, and we'll get Mr. Walker on screen and online with, I think he's already called in, so once
I'm online.
Okay. So we'll get your camera cut on, I think is the...
Yes, there's a button that says share my webcam.
There's a button that says
Share my webcam.
share my webcam.
I did, and there's a little black circle, and it's where I assume I would normally be, and it's just a black circle.
Well, that's not good.
No. Are you in the same computer when we did the test? Remember you had one that didn't work?
Yes. Yesterday I was on WebEx. Today I'm on Segra. But there's a little gear. What does that say? Done.
Okay, would that be best? So, because we need to get him seen. Okay, Mr. Hafer and Mr. Walker, if this works okay, we're gonna go ahead and go to the next witness and work on getting his picture up there so everyone can see him.
We can certainly do that, Mr. Chairman.
Okay, thank you.
So the applicant would then call Gary Walsh.
Okay, we'll wait to get Mr. Walsh on camera and
Mr. Walker, can you press stop sharing my computer? Thank you.
there he is. Okay, welcome, Mr. Walsh, and we will need to unmute your phone so we can hear you. Do you solemnly affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Welcome.
Thank you, Mr. Chairman.
Could you please state your full name and business address for the record?
Yes, Gary E. Walsh, 1828 Bull Street, Columbia, South Carolina.
Mr. Walsh, where are you employed and in what capacity?
I am employed as the president of the Walsh Consulting Group.
Mr. Walsh, have you caused to be pre-filed in this proceeding direct testimony consisting of 7 pages?
I did.
Do you have any changes, deletions, corrections, or revisions to your pre-filed testimony?
I have one change on page 2, line 17, strike the number 2 and insert the number 9 in reference to the order number and docket number 2012-273S, so it will now read order number 2012-960.
With that revision, Mr. Walsh, if I were to ask you the questions set forth in your pre-filed direct testimony, would your answers from the witness stand today be the same as printed therein?
Yes, sir.
Mr. Chairman, at this time I would move Mr. Walsh's direct testimony as revised into the record as if given orally from the witness stand.
Mr. Walsh's pre-filed direct testimony as revised will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Walsh, did you also cause to be pre-filed rebuttal testimony consisting of 17 pages?
I did.
Do you have any changes, revisions, deletions, or corrections to your rebuttal testimony?
I do not.
If I were to ask you the questions printed in your pre-filed rebuttal testimony, would your answers from the witness stand today be the same as printed therein?
Yes, sir.
Mr. Chairman, I would move at this time that Mr. Walsh's pre-filed rebuttal testimony be copied into the record as if given orally from the witness stand.
Okay, Mr. Walsh's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Walsh, did you also cause to be attached to your rebuttal testimony 6 exhibits totaling 65 pages?
Yes, sir, I did.
Mr. Chairman, this time I would move as the next hearing exhibit, Mr. Walsh's 6 exhibits totaling 65 pages.
Mr. Walsh's 6 exhibits, GW rebuttal exhibits 1 through 6 will be entered as hearing exhibit number 10.
Thank you, Mr. Chairman. Mr. Walsh, please answer any questions counsel for the consumer advocate or the commissioners may have for you.
Okay, thank you. Mr. Hall.
Good morning, Mr. Walsh. How are you?
I'm doing fine, Mr. Hall.
Good. Glad to have you here. I'd like to start by asking you about the Tax Cuts and Jobs Act.
Yes, sir.
I'm going to share a portion of your testimony here. Let me know. Can you see that?
If you could give me the page and line number, I have my testimony with me.
Sure. It is it's from your direct testimony, page 6.
Yes, sir.
Okay. So starting on line 14 there, you lay out some PUI's position about why the tax cut, the funds from the Tax Cuts and Jobs Act are not required to be refunded to the consumers, correct?
Correct.
And the first reason you state is that it constitutes impermissible retroactive rate making and improper single expense rate making, correct?
Correct.
Further down the page at line 23, you note that you have expressed this opinion in a previous docket in front of the Public Service Commission of South Carolina, correct?
That's correct. That would be the CUC case.
Correct. Have you testified to this same position in any other jurisdiction?
Have not.
Okay. Are you aware of any court cases or commission hearings where a court or a commission has determined that it would be retroactive rate making or single expense rate making to require a refund of the Tax Cuts and Jobs Act funds?
I am aware of a Supreme Court decision which found that in fact it is retroactive rate making when a commission orders refunds of a previously approved and lawful rate. So I am aware of that. However, I am not aware of a commission decision that has addressed the issue of retroactive rate making.
And that Supreme Court case is, you said it was for a rate change, correct? A refund of a rate.
That's correct. It was an SCE&G case where the commission ordered refunds in 1980, and SCE&G appealed that to the Supreme Court, and the Supreme Court ruled on that.
I'm not sure your familiarity with that case. Do you know if there were any statutes involved that may have influenced the court's decision in that case?
I am familiar in that as you read the decision, basically the commission had ordered refunds, I believe, of some past interchange revenues that E&G had received, and ultimately, again, the Supreme Court ruled that those refunds could not be required by the commission as they were retroactive rate making.
Sure. And in either case, that was in 1980, long before the Tax Cuts and Jobs Act that we're discussing now, correct?
Well, it was certainly in 1980, but since 1980, there's been an 86 Tax Cuts and Jobs Act, a 93 Tax Cuts and Jobs Act, and now a 2017 Tax Cuts and Jobs Act. So there's, and I would say, depending on what happens in November, there may be another Tax Cuts and Jobs Act. Who knows?
Certainly. So it surprised you that we've also searched and not been able to find any commission or court examples where specific to the Tax Cuts and Jobs Act was required to be refunded?
Objection, Mr. Chairman. That speculation by the witness as to what Department of Consumer Affairs might or might not have found.
He's testified that, this is a position he's taken before, and I'm just trying to figure out if, he's aware of any other times the commissions have determined it.
Okay.
I believe, Mr. Chairman, it calls for speculation by the witness about what the Department of Consumer Affairs might or might not have found.
Hey, Mr. Chairman, I may have understood it I believe I'd have to overrule Mr. Hafer's objection. I thought he was asking Mr. Walsh if he was familiar with any other decisions on this particular issue. Is that not a correct statement?
That's correct. I believe he did answer that part of the question. I'll withdraw it as asked.
Okay, all right. That'll take care of it then.
Thank you.
Thank you.
So, Mr. Walsh, before you formulated this opinion in either the 2019 case or in this current case, I assume, did you research this issue to see if other commissions or courts had ruled this way?
I researched it only through reading the documents that were filed in the 2017 docket that this commission put into place at the time of the Tax Cuts and Jobs Act.
Okay. Thank you. So I think that was the number, little number I here on the screen, impermissible rate making. The second point in your testimony is that refunding would deprive the company of due process of law. Do you agree with that statement?
Absolutely.
And again, the Tax Cuts and Jobs Act was implemented in 2018, correct?
That's correct.
And would you agree that the first step in the legal process would be for PUI to appear before the commission?
I'm sorry, could you repeat that?
Would you agree that the first step in PUI's due process would be to appear before this commission regarding the funds?
I would agree, and PUI tried to do that. They filed pleadings in the 2017 docket, and to my knowledge, the commission has not ruled on that docket.
But you would agree this hearing itself is part of their due process, correct?
I would agree.
Okay. I'm going to go to the third statement here. You say on line 17, PUI's position is that it's contrary to the provisions of the South Carolina Constitution regarding taking a private property for private use. Do you agree with that statement as well?
I do.
But these other positions aren't really discussed in your testimony, are they?
Other than what you referred to here.
Okay. But you did not elaborate on those other positions, only on the retroactive rate making component, correct?
That and the single entry accounting issue.
Correct. Okay. And then I guess finally on number 4, it's contrary to South Carolina Code 585290 as interpreted by the South Carolina Supreme Court. Do you also agree with that?
I do.
Okay. All right. I'm going to, I'll show you 585290. This section addresses improper rates. So I think that commission can address improper rates. Would you agree?
I agree. I have that in front of me.
Okay, thank you. All right, I'm going to, I'll stop sharing my screen now for the moment. So in your testimony, you also discuss contributions in aid of construction. Is that correct?
I'm not sure where I discussed that. If you could lead me there.
You don't recall what?
That was not part of my engagement in this case.
Bear with me just a moment. I'll see if I can find it for you. I'm looking at your direct testimony, page 3.
I'm there.
Okay. And what is the first question on that page?
How should the $18 million purchase price for the sewer collection facilities purchased from the city be accounted for?
Okay. And I'm just now attempting to share that. And could you read your answer, please?
Yes. In my opinion, the entire amount is required to be booked as at the original cost to the company under the uniform system of accounts without any adjustment for depreciation amortization, or contributions in aid of construction.
Okay, so just to confirm, your testimony does address contributions in aid of construction, correct?
Well, it addresses that, in my view, that $18 million should not be offset in this case by contributions in aid of construction.
Sure, I understand. I just wanted to make sure that was your testimony. I wanted to make sure I wasn't getting you confused with another witness. So I appreciate
No
you helping clarify that.
Yes, sir.
So would you agree that developers typically donate sewer lines to sewer providers as part of agreements to provide service?
I would agree that that is done in a couple of different ways. Sometimes the utility itself builds those facilities. At other times, developers donate that property.
Sure. And would you agree that if a developer donated property to PUI, it would be considered CIAC?
If a developer donated property to PUI, I agree, in the regulated environment, that would be a contribution in aid of construction.
Okay, thank you. I guess now I'm going to ask you about your opinions on the uniform system of accounts.
Yes, sir.
I'm just trying to understand your opinion here. So bear with me, please.
Sure.
So you would agree that the USOA provides basic accounting descriptions and instructions for utilities to follow, correct?
It provides basic instructions for regulated utilities to follow. A big distinction.
Correct. Yes. Thank you for the clarification. You're correct. Now, pursuant to South Carolina Regulation 103-517, PUI has to keep its books and records in accordance with the USOA, correct?
Correct. All regulated utilities have to.
So would you agree that the USOA is an accounting guideline and not a rate-making guideline?
It's certainly an accounting guideline that leads to rate-making decisions.
Correct. And it leads to rate-making decisions, right? But would you agree that the USOA does not provide rate-making instructions for the Commission?
Well, it certainly provides instructions for the regulated utilities how they are to maintain their books and records, which ultimately lead to the Commission making rate-making decisions.
Right. So the Commission uses the accounts that the regulated utility develops in accordance with the USOA. The Commission uses those accounts to then determine rates.
Correct.
So, again, like I said, I'm trying to understand your position on the applicability. Bear with me just a minute. I'm going to try to share my screen one more time. I'm showing page 3 of your direct testimony.
Yes, sir.
And I'm looking specifically at lines 20 through 21, where you state, to the contrary, the city is unregulated, and the USOA therefore does not apply to it. So am I correct that you believe the USOA does not apply to the city's assets purchased by PUI?
At the time of the acquisition, the Uniform System of Accounts did not apply because the city, per its own definition in the Uniform System of Accounts, is not a regulated utility and therefore not under the USOA.
Okay. And then also in your testimony, you discuss USOA instructions 18 and 21, and I believe you state that you do not believe the sewer lines PUI acquired are an operating unit or system, as mentioned in those instructions. Is that correct?
That's correct.
What do you consider an operating unit?
Well, certainly an operating unit, I think that the terms operating unit and system go hand in hand. And in this instance, in a wastewater system, you have to have collection, transportation, and treatment. And in this case, PUI acquired collection facilities which are of no use until you also have transportation and treatment. That's why this is not an operating system. Without all of those components, it's not an operating system.
It's not an operating system, but what is an operating unit? Because the instructions say operating unit or system, correct?
I look at those as similar terms.
As similar terms, but the USOA clearly uses both of them, correct?
And I do not believe you will find a definition for operating unit in the USOA definition section. I believe I tried to do that and could not, but clearly a collection facility is not an operating system.
Okay, but you described transportation, you described treatment, so the sewer lines provide transportation, correct?
Correct.
I'm going to try to share my screen again here, just so we can see what we're talking about, or so the commission can see. So here's USOA accounting instruction 18A. So that, again, that first sentence we're talking about, all amounts included in accounts for utility plant acquired as an operating unit or system shall be stated at the cost incurred. And so, again, it's your position that that does not apply because the sewer lines, for one of the reasons you say that does not apply is because the sewer lines are not an operating unit. Is that your position?
That's one of the reasons. The other reason is this is not utility plant. It was not acquired, when it was acquired from the city, it is not utility plant because, once again, the city is not under the uniform system of accounts.
Correct.
It doesn't become utility plant until such time as, in this case, the company is seeking to have that included in rate base.
Mr. Chairman, may I ask a question of Mr. Hall, please? Sir, would you mind identifying the page? It appears that you're going into Mr. Walsh's, one of his rebuttal exhibits. Would you mind identifying the page and exhibit number, please, just for the record?
Yes. Yes, sorry about that. I think maybe you can see it now at the top. It's GW Rebuttal Exhibit 1, and it's page 13 of 43.
Okay, thank you.
You're welcome. Okay, Mr. Walsh, so the second sentence states all other utility plants shall be included in accounts at the cost incurred. Do you interpret all other utility plant to mean other utility plant not acquired as an operating unit or system?
My interpretation is that the collection facilities that were acquired fits under the term of all other utility plant. That's correct, Mr. Hall. That's my belief.
So that's not an operating unit or system. You're not saying all other utility plant includes non-regulated utility plants.
No, what I'm saying is that the acquisition of these collection facilities did not constitute an operating unit or an operating system. So when you go to the second sentence in 18A, it states all other utility plant, and I define that as these collection facilities.
But these facilities were part of the city's system, and you have already said that the city is not a regulated utility, and therefore the USOA does not apply to its assets, correct?
It only applies when the utility company, after acquiring the system or the collection facilities, USOA only applies when the utility company is attempting to put it in rate base, which is what this company is trying to do today. In other words, they made this purchase in 2013, and here we are in 2020, and as of today, they've received no return on that $18 million investment. So that's what they're attempting to do in this case.
But the second sentence still uses the term utility plant, correct?
Well, it becomes utility plant after the utility has acquired it and when it is trying to put it in rate base. The USOA does not apply to this transaction until such time as the utility attempts to put this collection facilities and rate base, which is, again, what they're trying to do in this case.
Okay, so second sentence applies, first sentence does not. Okay.
I
think
agree. First sentence does not apply for a couple of different reasons, which I've explained.
Okay. Because you do not consider, for one of those is you do not consider sewer lines to be a unit of the system.
That's correct, a unit or system.
Okay. And just to clarify, without the sewer lines, the plant isn't treating anything, right?
That's correct. I mean, the collection facilities without treatment and transportation is of no value.
Okay. So without all the units operating together, the system doesn't have anything to do.
I would agree. The collection facilities themselves are of no value without transportation and treatment.
And just to clarify one other thing, the PUI did use the city's plant for, I believe, 2 or 3 years following the initial acquisition, correct?
That's correct. That was part of the purchase agreement, and that certainly codifies my point that without treatment, there is no value. Therefore, they had to enter into that type of agreement with the city until they had completed their own treatment facilities and were able to collect and treat at their own site.
Okay. All right. Thank you. I appreciate it. I have no more questions.
Thank you. Commissioners, any questions? Commissioner Belser. You just cut your mic off, Commissioner Belser. That's why I didn't call.
Good morning, Mr. Walsh.
Morning, Madam Vice Chairman.
How are you this morning? I want to follow up on that line of questioning that Mr. Hall was going down a little bit.
Yes, ma'am.
Suppose let's look at a hypothetical here. Let's suppose that a utility purchased from a municipality and a system such as we've been discussing here, but it's a hypothetical, at a grossly inflated value over really what was in the ground. And I don't know, let's just say, realistically, the plant might be worth $10 million and the company, for whatever reason, decided to pay $50 million. Under your scenario, would all $50 million be allowed in rate base under your testimony here?
Well, Commissioner, I believe that if you look at the uniform system of accounts, and that is the biggest problem in this entire case. Other intervenors in this case have tried to treat this transaction as if it was a regulated utility purchasing from a regulated utility. And if that was the case, we wouldn't be here today. But therein lies the problem, Commissioner, since this is the first incident of this type that I'm ever aware of that the Commission has had before. It has never had a proceeding to address a regulated utility purchasing facilities from a non-regulated utility. So I would have to say you would have to look at that on a case-by-case basis, Commissioner Belser, but I do believe that my reading of the uniform system of accounts would require that full amount to be put in rate base.
Well, is not one of the issues before that lends to the difficulty of the valuation here the fact that the City of Columbia really didn't have very good records on what was in the value of what was in the ground and what the utility was purchasing?
Absolutely, and that has been pointed out by a number of witnesses, and the reason is the city is not required to keep their books and records under the uniform system of accounts. So when they receive water and sewer revenues. Those revenues can be used to do any number of things, including the Bull Street project, which Mr. Walker alluded to in his testimony as part of the reason for this transaction.
And, but isn't there a fairness issue as well as a responsibility in the establishment of just and reasonable rates to determine a fair value and not just the $50 million paid in my hypothetical? That there be and I appreciate what the parties have put forth as far as evidence and testimony, but to ensure just and reasonable rates, there needs to be evaluation done, and not just saying we paid $50 million, and I understand, I'm not saying Palmetto did that. I'm talking about my hypothetical here, okay? We paid $50 million, we want that amount in rate base. How does that equate to our responsibility to set just and reasonable rates if somebody overpays? Okay.
Right. On page 5 of my direct, I might can give some guidance there. Starting at line 23, I have indicated the purchase price of the assets in excess of book value may be included in rate base when one or more of the following criteria are met. The transaction was in the public interest, the purchase price was reasonable, the benefits to ratepayers were equal or greater to than the premium paid, so on and so on. So certainly in my testimony I've included some language that would give the commission the ability to determine whether the purchase price was reasonable. And I have gone on in my testimony to indicate that I believe that the PUI has met all the criteria that I have listed here. Certainly it has been a huge benefit to the ratepayer, the 11,000 ratepayers that they acquired. Mr. Dade's testimony and chart exhibits that those customers since inception have saved almost $9 million, and over the next 3 years, assuming the city keeps its current rates where they are, which I think is probably a bad assumption, it will go up to almost $13 million. So certainly I believe that the company has met all of this criteria that I have laid out there on page 5 of my direct testimony.
And I know when we were talking, that we are talking a situation of purchasing a non-regulated municipal utility, but you were on staff here at the PSC for a number of years, is that correct?
32, yes sir, Commissioner.
And do you remember in a number of orders when dealing with acquisitions that the prior commission had always tried to, and I know it's not an apples and oranges comparison, but the commission usually, they always looked at, they didn't want the customers having to pay for the same plant more than once, and that was part of the valuation issue. Was that correct?
I agree. That would be a concept, and that certainly would apply in a public utility purchasing the assets of another public utility, again, whose books were kept in accordance with the Uniform System of Accounts. Therein lies the huge problem with this case. The city's books clearly were not kept in compliance with any system of account.
Mr. Walsh, thank you so much for your testimony. It's good to see you this morning. Thank you.
Good to see you, Madam Chairman.
Thank you. Commissioners, any other questions for Mr. Walsh? Hearing none, any redirect, Mr. Hafer.
Just very briefly, Mr. Chairman. Mr. Walsh, Commissioner Belser was talking to you about a hypothetical. And let me ask you, with respect to the city of Columbia, is it not your understanding that parties in this case have asserted that the vast majority of the assets purchased from the City of Columbia were contributed?
Yes, some parties have asserted that.
And if those were in fact contributed, would the City of Columbia's rates be based upon collecting from those customers revenues reflecting a return on an investment?
No, sir. The City of Columbia's rates are set at whatever level the City of Columbia decides to set those rates.
Okay.
Not
Thank
based
you.
on any of those principles.
I'm sorry. Thank you very much. No more questions, Mr. Chairman.
Thank you. Any recross on that question? Okay, thank you. Okay, Mr. Walsh, thank you for being here today. Appreciate your testimony, and you may step down. Okay, have we gotten Mr. Walker where we can see him now? The witness that we skipped.
Mr. Walker's on. I'm not seeing his video.
I have a blank. I have that black circle again.
Did you change computers?
No, I can pop it out of the dock that it's sitting in and use the default camera that's built into the laptop. I'll do that right now.
There we go.
Can you see me?
We can see you.
Oh, you can see me?
Yeah.
All right.
Good job. Good job. Okay, we'll ask you to raise your right hand, Mr. Walker. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, Mr. Hafer.
Thank you, Mr. Chairman. Would you please state your full name and business address for the record?
Sure. It is, my name is Harold Walker III, and my business address is 1010 Adams Avenue, Audubon, Pennsylvania, 19403.
Mr. Walker, where are you employed and in what capacity?
I'm employed by Gannett Fleming Valuation and Rate Consultants, LLC, as Manager Financial Studies.
Have you caused to be pre-filed in this case direct testimony consisting of 45 pages and a 7-page appendix?
Yes.
Do you have any revisions, corrections, deletions to your testimony and appendix?
I do not.
If I were to ask you the questions printed in your pre-filed testimony, would your answers today from the stand be the same as printed therein?
Yes, they would.
Mr. Chairman, at this time I would move that Mr. Walker's direct testimony with the 7-page appendix be copied into the record as if given orally from the witness stand.
Mr. Walker's pre-filed direct testimony with the appendix will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Walker, did you also have 2 exhibits totaling 95 pages appended to your direct pre-filed testimony?
Yes, I did.
Mr. Chairman, I would move at this time as the next hearing exhibit, Mr. Walker's 2 exhibits totaling 95 pages.
Mr. Walker's exhibits HW1 and 2 will be entered as hearing exhibit number 11.
Thank you, Mr. Chairman. Mr. Walker, did you also cause to be pre-filed in this case rebuttal testimony consisting of 34 pages?
I did.
Do you have any changes, revisions, deletions, or corrections to that rebuttal testimony?
I do not.
If I were to ask you the questions printed in your rebuttal testimony, would your answers today from the witness stand be the same as printed therein?
Yes, they would.
Mr. Chairman, I would move Mr. Walker's rebuttal testimony of 34 pages into the record as if given orally from the witness stand.
Mr. Walker's pre-file rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Walker, did your rebuttal testimony also attach a single exhibit totaling 2 pages?
Yes, it did.
Mr. Chairman, I would move as the next hearing exhibit, Mr. Walker's exhibit of 2 pages attached to his rebuttal testimony.
Mr. Walker's rebuttal testimony will be entered as exhibit number 12.
Thank you, Mr. Chairman. Mr. Walker, please answer any questions counsel for the consumer advocate or the commissioners may have for you.
Yes, sir.
Okay, thank you. And I think I misstated, but the exhibits attached to the rebuttal testimony that we're entering is number 12. Okay, Mr. Hall.
Thank you, Mr. Chairman. Before I begin with questions for Mr. Walker, Exhibit HW1 to his direct testimony includes a report his company prepared. Attached to that report is the asset purchase agreement that's been discussed during the hearing without exhibits. Therefore, I'd move to have Exhibit J and Schedule 3.1F of the asset purchase agreement entered as hearing exhibits pursuant to South Carolina Rule of Evidence 106. That rule of evidence provides that when a writing or recorded statement or a part thereof is introduced by a party, an adverse party may require the introduction at the time of any other part or any other writing or recorded statement which ought in fairness to be considered contemporaneously with it. Additionally, South Carolina Regulation 103-847 entitled Documentary Evidence provides that in case any matter contained in a report or other document on file with the Commission is offered into evidence, such report or other document need not be produced or marked for identification, but may be offered into evidence by specifying the report, document, or file containing the matter so offered. I present that Exhibit J and Schedule 3.1F are contained in the previous PY docket from 2012, 2012-273-S, I believe. I also understand that the hearing officer's instructions in this case previously stated to submit documents into evidence that were not otherwise in the record by Friday. I did not originally plan to use this document and had in fact not reviewed it until this weekend. Unfortunately, on Friday afternoon, PY and ORS presented potential stipulations to the department. At that time, we realized that our strategy, for lack of better word, may have to change in this matter, and we ultimately did not agree to those proposals. On Sunday afternoon, we were informed that the stipulations between PY and ORS had been agreed upon, and only then do we realize that we would certainly need to present additional information to this commission. I will note that the hearing officer's emails were a result actually of an initial communication from Mr. Hafer regarding impeachment processes. That is not the primary purpose of why I would like to submit these additional exhibits. During those discussions, Mr. Hafer noted that impeachment documents could be potentially prejudicial if they were shown to more than the witness and his attorney. I believe the example Mr. Hafer gave was that if, for example, the documents called someone a dirty dog, then the commission would not be proper for the commission to see that. Again, that is not the case here. These are already public documents obtained from the PSC website. The hearing officer's directive, or the emails regarding submission of documents noted, particularly there's an email July 8th at 1:47 p.m. that stated the goal of this process was to save time for all by streamlining the procedure for the out-of-record documents during the hearing. A second email was received Friday, July 10th at 10:45 a.m., which stated that the new procedure is intended to be a labor-saving device for the attorneys. Again, these are public documents. They were originally submitted by the company to the PSC in a 2012 rate filing, and therefore could be no surprise to them. In this case, PUI has submitted that part of the asset purchase agreement PUI has submitted part of the asset purchase agreement, but not the requested exhibits. So South Carolina Rule of Evidence 106 is clearly applicable. Part of PUI's argument is that CIAC is unknown and not measurable. Another part of their argument is that the city kept poor records. Yesterday, we heard that the city did have numerous as-built drawings for the neighborhoods and sewer systems it sold to PUI. We also heard how PUI's witnesses could potentially calculate the value of those systems if they knew what was conveyed to the city and when. The additional portions of the APA show this additional information and provide evidence that maybe CIAC is measurable and the city's records weren't so poor. Therefore, as provided in Rule 106, I believe they ought, in fairness, to be considered. And I would ask for they to be moved as an exhibit. Thank you.
Turn that over to the hearing officer, Mr. Butler.
Yes, sir. Thank you. Mr. Hafer, do you have any reply to that?
Yes, thank you, Dr. Butler. I do have a reply to that. Commissioners, one thing that Mr. Hall failed to tell you, they've had Mr. Walker's testimony in this case since March 10th. So here we are, how many months later is that? 4 months later, and this is the first time that the Department of Consumer Affairs has said, we need to cross-examine your witness about documents that were not attached to his testimony. So when we're talking about fairness, I think that's the first point the Commission should consider. Secondly, he's just said that they're not going to use it to impeach the witness. So that means what the consumer advocate is trying to do is to get into evidence, the record of evidence through the company's witness. They have not called Mr. Walker as a hostile witness. Third, if it's not attached to Mr. Walker's testimony, he can only speculate. He doesn't have the document, and there was never any assertion that he should have the document. So I would submit that it's not fair. This would be surprise to allow the Department of Consumer Affairs at the last minute to introduce into the record. In addition, as the Commission is aware, we had a pre-hearing conference in this case. The Department of Consumer Affairs could have raised this point then and said, we intend to call Mr. Walker as a hostile witness. They could have said, there's an evidentiary issue we need to raise. All of this is now being done at the last minute. The hearing officer has already ruled that these documents were inadmissible through another witness yesterday, and we don't see any difference between yesterday and today. We're still in the same position that we were. So we would object on those grounds.
Yeah, I have a question.
Mr. Butler, if you don't mind.
Yes, sir. Go ahead. I had a question for you, but go ahead.
Just to respond to Mr. Hafer, first, South Carolina Rule of Evidence 106 does not consider the use of the record. It merely states, and it's particularly if you look at the notes, that only when a partial document is submitted that the other party ought in fairness to be able to present the entire document. Second, I believe I said my primary purpose was not impeachment. At this point, I do not know whether it would need to be used as any impeachment for any witnesses. And regarding fairness and the fact that maybe we could have seen this 4 months ago, as I noted earlier, based on the last-minute discussions between PUI and ORS, our strategy changed. I think that's only logical that we would then begin to look at other aspects that we may need to present that would otherwise not be presented by ORS.
Okay.
Mr. Butler, may I respond?
Yes, sir. One more time, please.
If, as Mr. Hall said, a purpose might be impeachment, that's all the more reason why the Department of Consumer Affairs should have been required to adhere to the procedure that was ordered, which was if you want to cross-examine a witness about a document that's not in the record, you have to submit it in advance. They didn't do that. So they didn't comply with that procedure either. They've had 4 months to raise this, and they haven't done it. And frankly, I don't think it's fair to the company. And if they did try to impeach him and he doesn't know anything about the document, it would just be a waste of time. Thank you.
Hey, thank you, Mr. Haver. Mr. Hall, do you intend to use this document to try to impeach Mr. Walker, for example? I mean, you said you might.
I just need. So. To be frank, I don't believe so. Honestly, I guess it would depend on his answers to my questions.
I see.
I believe.
Okay. Well, I'll tell you what, I'm going to overrule Mr. Hafer's objection. I think you stated correctly that documents that have heretofore been entered into the commission records in other cases are admissible. I think this document is admissible under that principle. I would say, however, you know, if you intend to use it to cross-examine a witness, I do believe you're going to have to furnish that document and give that witness a chance to look over it before you ask any questions of him, of that document. And so with that in mind, Mr. Chairman, I would agree, I would overrule Mr. Hafer's objection. I would admit the document as the next hearing exhibit number 13, but would rule as a condition that if the attorneys wish to question any witness on the document, that the witness have a chance to look at the document before answering any questions on it. And I think that's only fair under these circumstances. You can't ask a witness questions on a document if he hadn't seen it. So under those conditions, Mr. Chairman, I think this should be admitted as hearing exhibit number 13.
Okay. We will then admit it as hearing exhibit number 13.
Thank you.
Okay, who's going to get that for court reporter for Ms. Wheat? That we need to make sure.
Okay, Mr. Hall, can you furnish the document for us, please, so that we can put that into the record?
Yes, I can.
All right, thank you.
Okay.
Might I inquire through the chair?
Sir, sorry.
Mr. Chair, might I inquire through the chair, is Mr. Hall going to provide this document to the witness before he asks any questions? So we can determine whether the witness.
He has to, according to Mr. Butler, he has to be able to see the document before he can ask questions on it, so.
Yes, I will provide it. I'll start my questioning, and then when we get to that point, we can address it if that's okay.
Okay. Okay, let's proceed.
Okay. Thank you. Good afternoon, Mr. Walker. How are you?
Good. How are you?
Doing well, thank you. Bear with me just a minute. I'm going to, so that this particular issue can be addressed sooner than later, I'm going to go ahead and kind of rearrange what I was going to ask you. Bear with me just a minute. Okay,
By
so
the
as
way,
part of
you're not. Excuse me, Mr. Hill. You're not on camera. I don't. I just see the Public Seal Commission. The Public Service Commission seal, and then I see like a half of a screen of me. So I don't know if there's a. The only reason I'm bringing this up is if you're showing me something, I can't see it. So.
Yeah, I'm not sure. Maybe the tech IT folks can address that. I believe I'm on a different system than you, so I'm not sure if I can help you resolve that.
Okay. All right.
Hang on one second. We'll see. We're seeing everybody here.
All right.
On our screens.
I see Mr. I see Mr. Hafer and myself, and then I see initials for AH, but no picture for AH.
Are you on through WebEx?
No, I'm on Segra.
Yeah, okay. Do you see anything that says RH or Roger Hall? I'm RH.
No, the left-hand side of my screen is the seal of the Public Service Commission. The right hand, and then there's a picture of me, and now it just got bigger. I can see Mr. Hafer. I can start to see somebody to his right, but I have I just see his shoulder with a brown black background.
Okay.
Behind the shoulder.
I think that's me.
Right hand.
Yeah, that's.
All right. Well, how do I get you?
Let's get Mr. Hall. I think if you can send Wait, send it here, Ms. Boyd? Okay. Yeah, okay. Mr. Hall, let's go ahead and try to share your screen and let's see what happens first and see if
Okay,
everybody can
sure.
see it. And then if not, we'll try something different. And
I have a feeling so.
thank you, everybody, for being patient with a virtual hearing.
I can see the screen.
Can you see that
I
one?
can see a text. I can't read it, but I can see that there's a highlighted testimony.
Okay, let's see if we can blow that up a little bit.
Okay.
Mr. Hall.
I have my testimony here, so you could.
There you go.
All right, that's my direct testimony.
Okay, can we move ahead, continue, everybody see everything they need to see?
Yes,
I
Mr.
can see
Chairman.
it. Yes.
Hafer, I would ask that Mr. Hall identify what page of the testimony this is. That's cut off.
Okay,
Certainly. Certainly, I had not planned to share it at this time, but that's fine. As the chairman said earlier, I don't know that he needs to see me necessarily. So if he can see the testimony or what I'm sharing, that would be fine.
okay, if you'll
Mr.
give us
Walker,
the page number, Mr.
Yes.
Hall.
Yes, sir. Okay, well, Mr. Walker, if anything changes or you can't see or I need to, do something else, just please let me know.
Sure.
So part of your testimony is related to contributions to native construction or CIC, correct?
Correct.
Okay. What I have on the screen here is your direct testimony, page 2. The filed copy, I believe, is page 6 of 57, and it's showing lines 1 through 17 on the screen. That first line, starting at line 4, it states PUI engaged Gannett Fleming valuation rate consultants to provide an opinion on the probable value of the CIAC related to the acquisition of some wastewater assets owned and operated by the City of Columbia. Is that accurate?
Yes, the testimony speaks for itself. Yes.
Sure. Okay. Line 12, that's the next highlighted section below that. I'm just reading it just for your benefit in case you can't make it out. It says, in 2012, the Palmetto of Richland County LLC, PRC, and the city entered into an asset purchase agreement, APA, as part of the sale of the city's sewer collection system. And again, just want to make sure that's an accurate part of your testimony. Bear with me, I'm going to I'm going to try to share a different document now.
I can see you, by the way.
Oh, great. How are you? Just a second. Okay. All right, now, Mr. Walker, I'm showing your exhibit HW1, and this is a report prepared by your company, Gannett Fleming, correct?
Correct.
Okay. Scrolling down, bear with me, it's not how I was planning to do this, but we'll make it work. This is, again, your HW1 exhibit. This is page 2 of the report, sources of information, and highlighted there is the 2012 asset purchase agreement between Palmetto, Richland County, and the City of Columbia. So I'm correct to assume that one of the sources used for your report was the asset purchase agreement, correct?
The asset purchase agreement that I could download on the internet, which
Okay.
I don't believe has any of the attachments that are at issue.
Okay, we'll make sure in just a couple of minutes.
I included exactly what the document was in my in Exhibit HW1. So whatever I included is what I was able to download.
Okay. So right now we'll presume that you haven't seen it, but just let me just make sure, and then we can show you the document offline if we need to, just to make sure. So you said you reviewed the asset purchase agreement. So we've got that squared away.
Right.
I'm going to scroll to page 4 before of your document. And this is entitled Overview of the APA. So you provide a general overview, talking about when it was signed. Here you have, I will admit, have copied a section of the asset purchase agreement that is in your testimony titled Assets. And just in case you can't see it, I will read it. So, assets shall mean all right, title, and interest in and to all the assets owned by the seller and utilized exclusively in the operation of the seller of the city system. Next part I highlight, including all other appurtenances and without limitations, the real property described on Schedule 3.1F. Do you see that?
I see that.
So just make sure you were asked to look at the assets they acquired, which here in the document in your report cites that includes 3.1F. Do you recall if you reviewed Schedule 3.1F?
No, as I stated 2 minutes ago, what I included in my exhibit is exactly the document I reviewed. It had no attachments. I had downloaded it from the internet. I don't know offhand if I got it from the city's internet site or if I got it from the PSC website, but the document that I downloaded had no attachments to it.
And so as part of you were again retained to review the assets purchased and determine the value of the contributions in aid of construction, but you did not review all of the assets from the city.
To clarify, I was engaged to determine the value of contributions related to the expansion of the wastewater treatment plant owned by the city. That was my specific task. The contributions in aid of construction related to the wastewater expansion plant owned by the city. And that's what it states in my testimony.
So you only looked at the expansion fees.
Correct.
Okay. I'm going to share one more time. So this is from from your direct testimony. It is page 3, filed version, page 7 of 57. At the top, when you say that you can state with complete certainty that the value of the CIC related to Palmetto Richland County's 2013 acquisition of some wastewater assets owned and operated by the city was 0, it should be carried on the books as 0. This statement only applies to expansion fees and not any other developer contributions.
Yes, my analysis considered expansion fees.
So if there were, again, other developer contributions, you did not review that, and you cannot speak to the value of those assets.
I can't give you a dollar value if there were any, but based upon the records that I've seen, there aren't any.
Correct.
But my testimony you're asking me about is expansion fees. But globally, the documents I looked at, the city has no records. They had no records. They're your typical municipality, which your typical municipality has horrible records. They keep books in a different manner in which a public utility keeps books. That being said, the records, even the information needed to recreate, if you could recreate, don't exist.
Or at least you did not review them, correct?
They don't exist. I've reviewed everybody else's testimony. I've reviewed Mr. Roy's testimony. I've reviewed Mr. Rolchaw's testimony. They don't exist. If they did, those witnesses would have put them forth.
Well, but again, you only reviewed the documents that you were able to find online.
As did everybody else.
What I'm saying is you can't say they do or do not exist, correct?
I can say that based upon reading Mr. Loy's testimony.
I'd like to show you the hearing exhibit that's
Mr. Loy, excuse me.
record.
Mr. Loy's testimony, in his direct testimony, is replete with mention of the lack of records. I mean, that's my phrase. That's not necessarily his phrase, but.
Sure. Well, Mr. Roy, I'd like to show you Schedule 3.1F that was just entered as a hearing exhibit. Now, as you can see, this is part of the asset purchase agreement, and it notes the real. Can you see that?
We can't see it on
You
our.
can see Roger Hall is sharing is.
Yeah, we don't see the document,
starting to
Mr. Hall.
share.
Okay. Yeah, it shows that I'm sharing. I'll try it again.
There we go.
And so this is, again, you see at the top, Schedule 3.1F, real property transfer. And you see the right side, can you see where it says property ownership, deed to lift station, equipment, and facility?
Can you make that any larger, Mr. Hall? Thank you.
And so, Mr. Walker, I would just report that this document then does go on to show various deeds that were submitted as part of the asset purchase agreement, and that indeed these other documents do exist.
What deeds?
Documents that show other assets conveyed to PUI.
It shows real estate.
Pursuant to the asset purchase agreement.
Mr. Chairman, I've got to
The document.
Mr. Chairman, this
Yes,
is John
Mr. Hafer.
I'd like to make a. Now, Mr. Hall has gone on and on about this document, and Mr. Walker's already testified he hasn't seen this document. But Mr. Walker testified about the city's records. That, according to Mr. Hall, the document he's looking at is an exhibit to an asset purchase agreement. So this witness can't possibly testify about a document he doesn't know and about a document that is not a city record, but is an exhibit to the asset purchase agreement. So we would object to this line of questioning.
Okay. Thank you, Mr. Butler.
Yes, Mr. Hall, what do you say?
The exhibit is simply shown. The exhibit is simply shown due to Mr. Walker's testimony that these documents do not exist.
Mr. Chairman, the witness did not say that document didn't exist. He said that Mr. Lloyd testified that the city accounting records were bad, and if there were documents in the city accounting records, they would have been produced by Mr. Lloyd or another witness, and they have not been.
Okay. I'll have to sustain the objection.
Thank you.
Thank you. Mr. Walker, your testimony also included as an exhibit a 1998, I believe, I'm going to find the statement of revenues, expenses, and for the city of Columbia. Is that correct?
I assume you're referring to my rebuttal testimony?
Yes, sir. Rebuttal Exhibit 1.
Yes, I have a copy.
And I've just shared it on the
1998.
screen as well. Yes. And I just a
Okay,
brief
hey,
question here. will
I
try to
need for
expand it.
both of you, please, to don't talk over each other. Court reporter can't, there's a little delay, so both when you make a statement, pause for a second or two so that you're not talking over each other, because it's not doing us a bit of good.
Yes, Mr. Chairman, sorry about that. I did not realize the delay was causing the issue. Mr. Walker, can you see this document?
Yes.
Okay. And what was the purpose of your submitting this document in the record?
Mr. Lloyd claimed that the city wasn't recording contributions, and I provided a document showing that, in fact, I mischaracterized Mr. Lloyd's testimony. Mr. Lloyd's testimony, and the exact phrase is in my rebuttal, stated that prior to 2005, I believe it was, the city was not recording contributions. And I provided this document as proof that, in fact, they were recording contributions.
So the city did keep track of contributions, at least at some point in time?
Yes.
Okay. All right. Thank you. I will change my line of questioning now. Thank you. Bear with me just a minute. Okay. Thank you.
Before you, Mr. Hall, before you continue on with that, we're gonna take a break. We're gonna take 10 minutes.
Okay.
We will come back at 11:30.
Okay.
Everybody will stay on the line. We'll be back at 11:30. Okay, welcome back. Before we continue here, we need to call the roll and make sure we got all commissioners. Vice Chair Belser,
Here.
Commissioner Whitfield,
Here.
Commissioner Hamilton,
Here.
Commissioner Howard,
Here.
Commissioner Irvin.
Here.
And Commissioner Randall is here also. So, okay. So we've got everybody here. Now we're still with Mr. Walker, and I think still with Mr. Hall's questions.
Yes, thank you, Mr. Chairman. Mr. Walker, before I move on, there was one other thing I meant to ask you about the City of Columbia's 1998 balance sheet that you showed. I'm going to try to share this really quick, and then we'll move on. So again, this is your HW Rebuttal Exhibit 1, page 1 of 2. And I believe we were on the second page earlier. And I don't know if can you see the highlighted portion?
Blow that up a little bit if you can.
Yes, sir.
Mr. Chairman, this is John Hafer. I just need to note, I don't see Mr. Walker on the call.
There he is.
Mr. Walker? Thank you.
Mr. Walker, can you hear me? This is Roger Hall.
I can hear you, Mr. Hall.
Okay. Okay, great. The section I've highlighted, we were talking about how the city did document contributions, and right there, the third line down, do you agree that says from subdividers, $60,418,645?
Yes.
Okay, and I'm just going to scroll up just to show, and that was in the Water and Sewer Facilities Fund. Correct?
Correct.
Okay, thank you. Okay. So Mr. Walker, I'm gonna want to ask you about, I guess maybe some of your criticisms of the department's witness Aaron Rothschild's calculations. On page 27, lines 9 through 10 of your rebuttal testimony, you note that one of the areas of disagreement with Mr. Rothschild, with Mr. Rothschild's CAP-M is related to his beta. Correct. You have issues with Mr. Rothschild's beta.
Yeah, I'm sorry.
And
what page was that?
I'll put the testimony up as well if you want to look at it. Page 27.
Okay, yeah, it would help me much more if you just told me the page number.
Sure.
27.
Page 27 of your direct test. Of your rebuttal testimony, lines 9 through 10.
Yes.
Okay, y'all try not to talk over each other, and go ahead, before you introduce anything, go ahead and tell us the page number and where it's coming from. That will help the court reporter immensely and help all of us, so we'll know what the heck you're talking about. Thank you.
Sorry, Mr. Chairman. So again, Mr. Walker, the wording's not important, but one of your issues with Mr. Rothschild is his CAP-M is related to his beta, correct?
Yes.
And just for the record, I'm going to state the page numbers and where it's found. But if I don't think the exact wording isn't so important, I will pull it up and show you. Just if you disagree with the context or the concept of what I'm saying, let me know, and then we can find the exact language if you'd like. Does that make sense?
Yes.
Okay. Again, for the record, on page 27, lines 17 through 18 of your rebuttal testimony, you state that Mr. Rothschild calculates his own unique betas and did not use published betas. Is that one of your concerns?
Yes, that's a repeated concern I have regarding Mr. Rothschild's testimony, is that instead of using published information, he calculates his own. And that information might be fantastic it might be correct. However, the market is not aware of its existence, and therefore that information is more than likely not reflected in market prices.
I understand. And you use published betas, correct?
Correct.
Which betas do you use in your CAPM?
They're published by Value Line.
And did you use the 5-year historical betas from Value Line?
They're not labeled as I don't believe they're labeled as a 5-year beta, but they're the beta that appears on the Value Line page each quarter that they update the review of the company.
Okay. See, I will show you this specific page. I'm looking at page 27 of your rebuttal testimony, lines 18 through 21, which state, the market required cost of equity represents what the market will pay for a stock based on investors' expectations and assessment of risk. Beta. Is that correct?
That is correct.
Now, when you say market required, you mean return on market prices, for example, return on the market price of a stock, correct?
Correct.
I'm going to bear with me just a minute. It's a little bit out of order. So in your testimony, you also explained that you used a comparable group of publicly traded companies to estimate the cost of equity cost rate because PUI is not, there's no market data for PUI, correct?
Correct.
Okay. And you chose to calculate your cost of equity based on companies with publicly traded shares because the market price of securities helps measure the market-based cost of equity, correct?
Correct.
And while you said they're not calculated, Mr. Rothschild's betas are based on the published prices of securities, in this case, stock options, correct?
That is my recollection, and again, his betas may be the best betas in the world. I don't know that. My point is that they're not published, and therefore the market is unaware of their existence. If they were published, Mr. Rothschild would have cited them, but they are not. They're unique to Mr. Rothschild. Our exercise here is not to determine Mr. Rothschild's estimate of the cost of common equity. Rather, it is to determine the market's required cost of equity. In other words, it's not my opinion. It's not my cost of equity. It's not Mr. Rothschild's cost of equity. Rather, it's the market's cost of equity. Therefore, the information must be published or in the public, where the public to reflect that information in stock prices.
I understand that as your position. So the Chicago Board of Exchanges Market Volatility Index, or VIX, VIX, and SKU indexes, they're calculated based on stock option prices, correct?
Correct.
And the CBOE's VIX and SKU indexes are used by investors to gauge market risk, correct?
Correct.
And Mr. Rothschild used the same mathematics used by the CBOE to calculate VIX and SKU in order to calculate implied volatility in SKU, correct?
I don't know that.
Will,
Mr. Rothschild could testify to that.
Okay. Let me I will try to, let me see if I can find it in his testimony here. At least we can determine that is indeed what he stated. I'm looking on page 50 of Mr. Rothschild's direct testimony. And then I'm just going to read, I'm at line 15 towards the bottom. And he's starting to describe his process. He says, I start my process with publicly available trading information for all the options for a given security, then filter the options data as described by the CBOE using the following guidelines. And he then goes on, carries over to page 51, and he describes those guidelines. Now on page 51 of his testimony, at line 9, and he states, I then applied the series of formulas clearly described in both of the CBOE's white papers to the remaining options to calculate option-implied volatility and option-implied skewness. So can we at least agree that Mr. Rothschild has stated that he does indeed use the CBOE mathematics to calculate?
To calculate implied volatility.
Correct.
That's what he's testifying to there. He's not testifying to beta, he's testifying to option implied volatility.
Okay. And implied volatility and option implied skew are a direct measure of an investor's expectations for covariance, correct?
That I don't know.
Okay. Well, are implied volatility and option implied skew based on published market data and published methodologies?
Well, I don't. If the data were published, it would be cited, but it's not. What Mr. Rothschild is testifying to, and again, this is my interpretation, Mr. Rothschild should be testifying to this, not me. He is testifying that he looked at information published by CBOE's white papers, which I don't know what that means. And he calculated an implied volatility and implied skewness. He doesn't say that CBOE calculated it. He says that his interpretation based upon CBOE's white paper was used to calculate these numbers. My point being, CBOE does not publish this information. Therefore, it can't be of any use to the market. It doesn't exist.
And to clarify your position, published betas are required because, as you say in your in your rebuttal testimony, real investors rely on them.
Whether it's betas, whether it's growth rate, my point, and I repeat the point in my rebuttal testimony, that Mr. Rothschild's unique positions, they may be correct. I'm not saying they're necessarily incorrect, regarding the mathematics. My point is, nobody knows they exist. They're unique to Mr. Rothschild. The market is not aware of Mr. Rothschild's existence any more than it is aware of my existence.
I got it.
I think we've made this point, so I think it's time to keep moving.
Yes, I am. Yes, sir. So you said earlier that you used Value Line's historical beta, correct?
I use Value Line beta. Now, whether or not, I don't know why you're classifying it as historical beta. I'm not sure why you're classifying it as that. It's not classified by Value Line as a historical beta.
Okay.
It's a current beta at the time of publication.
Okay. Is Value Line's beta the only published beta available to investors?
No, I assume there are other betas available. I believe it is the most commonly available beta.
Okay, but
I can't see offhand other services that provide beta. Merrill Lynch used to, but that was a decade or more ago. I don't know of other services that provide beta offhand.
So you're saying Value Line is the only service you know of that provides betas?
For water utilities, I'm not saying it doesn't exist. I'm sure if we researched it, we could probably find some other published betas if that is what you're looking for. But
Yeah,
no witness has done it.
Forget the focus on water utilities. For publicly traded stocks, are there other sources of published betas for publicly traded stocks?
Chairman?
Yes, I do not
Yes.
know.
Mr. Hafer.
I want to object. The question's been asked and answered 3 times.
I believe he misunderstood that I was only directing it to water utilities, and I wanted to clarify that my question is not just published betas from water companies. It's
Okay, Mr.
other
Hall, go
any
ahead and
publicly traded
clarify.
stock.
Yes, sir, go ahead and ask him that question, but we would appreciate it if you'd move on.
I understand, sir. There's certainly a point to the questions. So, Mr. Walker, Yahoo Finance, Bloomberg, Value Line, TD Ameritrade, are you familiar with those publications that they publish betas for publicly traded stocks?
Yes, I'm generally aware of it. I don't know that, in fact, they have them for water utilities. That's really my point. Water utilities are sort of unique, but yes, I am aware that other services are available with published betas. Not a single witness, not Mr. Parcell, not Mr. Rothschild, not myself, relied on any other service or beta.
Okay. And those publications that I mentioned, they publish different betas for the same stock, correct? 1 year, 3 year, and 5 year historical betas?
It depends on the publication.
Correct.
And again, I don't know the implication of 1 year, 3 year, 5 year, other than I assume it's the data period over which the beta is calculated. In other words, based on 1 year of information, or 3 years worth of information, or 5 years of information.
And when we're talking about investors in general, looking at all their stock options, it's not possible to know which betas a particular investor uses, correct?
No, and we're not interested in a particular investor. We're interested in the market, which is a consensus of investors.
And regardless of which betas investors use or don't use in their financial models, or however they form their return expectations, security prices are influenced by those expectations, correct?
Correct.
And so just like the CBOE's VIX shows volatility expectations, Mr. Rothschild's beta calculations estimate investors' expectations.
I don't know that.
But that is the point of him calculating betas to judge investors' expectations, correct?
Mr. Chairman, this is John Hafer again. Jack,
Yes, Mr.
Mr. Hall
Hafer.
asking this witness to speculate what Mr. Rothschild is doing.
I agree, sustained.
Okay, we've
Beta
sustained.
calculations in general estimate investors' expectations of covariance, correct?
They measure past covariance.
Thank you. We'll move on. Another concern that you had with Mr. Rothschild's testimony was his CAPM risk-free rate. Is that correct?
Yes.
Okay. And I believe your concern was that his risk-free rate is based on the short-term 3-month Treasury bill. Is that correct?
Yes. I believe the life of the asset should be the basis for the risk-free rate chosen. And because we're looking at long-lived assets, you should be looking at long-lived Treasury instruments. In all fairness, and I mentioned that on page 27, my rebuttal, Mr. Rothschild looked at both 30-year and 3-month. My dispute, if you will, or criticism of Mr. Rothschild only relates to the 3-month because 3-month risk-free rate is not reflective of the risk of long-lived utility plan.
Okay. And what interest rate do you use for your risk-free rate in your CAPM?
A long-term treasury bond yield.
Is it recent and forward long-term treasury yields?
I'm sorry, could you repeat the question?
Did you classify it as recent and long-term treasury yields?
I don't know if that's you'd have to cite me to the testimony.
Yeah, let's confirm really quick. Let's see. I am on page 36 of your direct testimony. I am at lines 27 through 29. Line 27 states, previously I estimated an appropriate risk-free rate of 2.4% based upon the recent and forward long-term treasury yields?
Yes.
Okay. Do you know what the market yield of the 30-year U.S. Treasury was at the time you filed your testimony?
When I filed the testimony, when the testimony was filed, or when I wrote the testimony?
When you filed the testimony.
I don't know. When the company filed the testimony or when I wrote the testimony? Because there's different time periods. In other words, the testimony would have been filed in, I don't know, was the case filed at the end of February or perhaps the beginning of March. And I believe the analysis is up through January. So that's I'm just trying to narrow what you're asking, whether you're asking about the filing date at which I wouldn't have known what that information was when I was writing the testimony because it hadn't occurred yet, or whether you're asking, at the period I was writing the testimony, which is it's in the testimony, whatever the risk-free rate was, it's presented in the testimony.
Well, one of your criticisms was that of Mr. Rothschild was that the yield had increased 46 points since he filed his testimony, right?
I don't believe that was a criticism. I believe I pointed out for the record.
So you're not saying it's a criticism. You're just pointing out that it was different.
Yes.
So I assume there's some relevance to that. So in other words, market yields are relevant.
Yes, that's a component of a CAPM.
Okay. All right. Thank you. I will move on. I want to ask you about your discussion about market to book ratios. I'm trying to share here. I believe you can still see it. Looks like page 31 of your direct testimony. And I'm specifically looking at lines 6 through 9. And here you state the comparable companies, which is your proxy group, their current market to book ratios are 383%. Is that correct?
That is correct. At the time the study was done, yes.
Yes. So in other words, at that time, the market price is almost $4 for every $1 of book value, correct?
Correct.
Okay. So when a water utility adds $1 to rate base, it will add almost $4 to market value, correct?
No. When a company adds $1 to book value, it'll add almost $4 to market value.
Would you agree that the book value of water companies is about the same as their rate base?
No.
You would not agree?
The book value is just the equity component of the rate base.
Okay. So if a water utility adds $1 to rate base, and there is a 383% market to book ratio for these companies, that would add almost $4 to market value, correct?
No. Rate base is financed by a mix of investor-provided capital. So when you add $1 to rate base, you're also adding some dollars to investor-provided capital. Now, whether that investor-provided capital is book value or whether it's debt, that's where we're differing on the question you're asking and the answer I'm giving you.
Sure.
In other words, when you add $1 to rate base, we don't know, is that dollar equity? Is that dollar debt? Is it a mix of debt and equity? We would need to know that information in order to determine what its impact would be on market value.
If they add $1 to rate base, would that increase book value by the same amount?
No, it would depend on the financing mechanism.
So generally, if a water utility acquires a municipal system, based on the numbers you provided, would its market value be about $4 for every $1 of the acquisition price?
No.
Depending on the financing?
The market it all depends on the mix of capital, on the financing of the capital.
But depending on the mix of capital, it could potentially increase the value, $4 for every $1.
Mr. Chairman, this is John Hafer. I want to object. The question has been asked and answered 3 times.
Agreed, sustained.
For clarification, and Mr. Hafer can object again, if the capital structure was 50-50, what would $1 of book value do to market value?
It would depend on the new source of capital.
Okay. Fair enough.
Your 50-50 is an existing capital. All right? When you add rate base, it needs to be financed by some mix of capital. So what would its implication be on market to book ratio is what you're asking. And I'm saying you need to give me that little tidbit. You need to tell me what the...
I understand, and I won't ask the hypothetical. But your testimony is that there is no economic incentive for a regulated buyer to pay more than is necessary to win a bid to purchase the assets.
You're referring to rebuttal testimony?
Let's see. Yes, page 4 of your rebuttal testimony. Lines 8 through 11.
Eight to 11.
And I've highlighted it on the screen.
Yes, I see it.
So you're saying there's no economic incentive for a regulated buyer to pay more than is necessary to win a bid to purchase assets because a regulated buyer is only entitled to the opportunity to earn a fair rate of return on their investment as determined by the regulator.
Correct.
But what I'm hearing you say is that depending on the structure that the market value could be increased by a certain percentage above, again, you indicated 383% for the regulated water companies, depending on how the purchase was financed, potentially it could go up almost $4 for every $1 purchased.
Mr. Chairman, I'm going to object. That's not the testimony of this witness. And that-
Mr. Chairman, I
Okay.
believe the testimony, he said that for the market-to-book ratio for the comparable water companies was 383%. I'm just trying to understand what that means.
And I
believe
renew,
he said
my
it-
Chairman, the
Yes, sir.
question has been asked.
Mr. Hafer, I think let's give Mr. Hall one more chance, and whatever response he elicits, that should be the end of it. Go ahead.
Thank you, Doctor.
Thank you, Dr. Muller. So again, you testified 383% market-to-book ratio. Testified that depending on how it's financed would influence how much an investment into rate base, how much that influences the market value. But here you're saying there's no incentive to pay more than the bid price. And all I'm asking is, depending on the structure and based on that percentage that you gave, the market value could be increased exponentially from what was actually paid.
Again, I got to object. That wasn't a question. The witness has not used the word exponentially. There's no foundation. I would object.
Is it possible that it could go up 383% based on your market-to-book ratio that you provided for the comparable group?
Object, asked, and answered.
I
Was the
agree.
answer yes?
I think, Mr. Hall, you need to wrap this up. I'll give you one more chance, and that's it. I think Mr. Haver has valid objections, but yeah, wrap it up, or we will sustain his next objection if it's similar.
Mr. Walker, is that correct? That 383% indicates that potentially it could go up, an investment of book value could increase the market value by 383%.
No. It's dependent on the return determined by the commission. And that's what is stated in page 4. That's page 4 of my rebuttal, and that's why there's no economic incentive.
And would you agree that when a regulated utility requests a rate increase or increases their rate base as a result of an acquisition, they have the burden of proof? In other words, if the utility can prove that their rates are just and reasonable, the commission should give the rate increase.
Objection, Mr. Chairman, calls for a legal conclusion by the witness.
Agreed, sustained.
All right. I'll move on. All right. Thank you for your patience, Dr. Miller and Mr. Hay. Commission. Mr. Walker, I want to ask you about the capital structure of PUI. I believe you testified that for the test year ending August 31st, 2019, the company had a 41.79% debt and 58.21% equity. Is that correct?
That is correct.
In your testimony, you also provided a 5-year analysis of the company's capital structure from 2014 to 2018.
Correct.
Okay. In your testimony, I believe you included Schedule 3 of Exhibit HW2 that shows that analysis. I'm going to share it briefly. Now, I've highlighted what I believe are the historic numbers. Are those, did I highlight the correct portion? Are those based on your analysis, the capital structures from 2014 to 2018?
Mr. Chairman, might I inquire through the chair what page number we're looking at?
Can we get that page number?
Thank you.
Exhibit HW2. His is labeled page 5 of 48. The commission has stamped it also page 5 of 48.
Thank you.
So Mr. Walker, is this accurate that in 2000, am I correct in saying that in 2018 the company's capital structure was, for instance, first column 74.2% debt and 25.8% equity?
Yes.
And over on the far right there, you've got the average, the 5-year average was 72% debt and 28% equity. Is that correct?
That is correct.
Why the big difference in those 5-year averages to the test year of 2019, which I believe we established was roughly 42 and 58%?
There appears that there was a large infusion of equity. And I don't have the balance sheets, but the balance sheets, I assume, were part of the filing, and it would show the dollar amount of equity that existed at August 31, 2019.
And the higher the equity percentage, the more money PY potentially could earn, correct?
Could you state the question again?
Well, so equity is more expensive than debt, correct?
Yes.
And a higher percentage of equity leads to a higher rate of return, correct?
In theory, they should offset one another. In other words, if you have a low equity ratio such as 25%, you should have a much higher return on that equity, so that the overall rate of return for the company is the same, regardless of the capital structure. At least that's the financial theory regarding valuing firms.
But a higher percentage of equity. Go ahead.
The reason the equity ratio would change so dramatically is this is such a small company that you put $1 in and the equity ratio jumps up. Whereas if you're talking about a large company, you put $1 in, you have very little impact. This is quite common with small companies in terms of volatility in their capital structure.
I guess given the difference, the drastic difference in the last 5 years, why should the commission believe that the current structure will be maintained?
I don't know that there's a requirement for belief. A test year is a point in time, and it's what exists at a point in time, and whether or not it's reasonable compared to other entities. All witnesses, Mr. Parcell, Mr. Rothschild, myself, looked at the capitalization ratios for other water utilities and determined that the capitalization for PUI was reasonable. Now, we differentiated slightly in our equity ratio, but for the most part, they're fairly identical. They're all in the 50s. My recollection, I used the per books number at August 31, 2019. Mr. Parcell recommended 55%, and I think Mr. Rothschild recommended 53%. So, generally speaking, we're all about the same. Because they looked at the information that existed at the end of the test period, and we compared it against comparably traded companies, and that's what our recommendations are based upon.
And just to clarify, where does PUI get its equity from?
From its parent.
And that's the only source of their equity, correct?
Correct. Well, other than retained earnings.
Right. I believe that's all the questions I have, but give me just a minute, Mr. Walker. I appreciate your patience.
Sure.
That's all I have. Thank you.
Thank you. Commissioners, questions? Commissioner Belser.
Good afternoon, Mr. Walker.
Good afternoon.
Mr. Walker, are you familiar with the stipulation that Palmetto and the Office of Regulatory Staff signed and filed with the commission?
I assume you're speaking about the current proceeding, and
Yes, sir.
I know there was an agreement. Yeah, okay. And I know there was an agreement. I've never seen the agreement, and I don't necessarily know the particulars within the agreement.
Would you bear with me and let me throw out some numbers to that and gauge your response to some of these points? In the stipulation, and when I say the parties here, I'm talking about the parties to the stipulation, and that's the utility and the Office of Regulatory Staff. The consumer advocate is not a party to the stipulation. So understand that from the get-go, please.
Yes, ma'am.
The stipulation adopts a capital structure of 45.4% debt and 54.6% equity. Based on your analysis, and I know your cost of debt and cost of equity, or your percentage of your capital structure was slightly different, is based on your analysis and your expertise, is the capital structure that is adopted in this stipulation, is that in the realm of reason?
Yes, it is. Page 13, page 12 of my direct testimony, I present a summary or a comparison summary of capitalization ratios for investor-owned water utilities. And the range there was 53.2% at September 30th, 2019, and the projected ratio for the same group was 56.6% for 2023. So that those ratios seem reasonable that you mentioned.
And I note in your rebuttal testimony on page 7 and 8, you with me?
Yes.
I'm at the bottom on page 7, beginning at line 16, and going over on the top of page 8. You reference Mr. Parcells' use of a hypothetical capital structure and what he came up with. And you reference Mr. Parcells' Exhibit DCP2, Schedule 4. And I don't know if you have that available. And let me see what I did with mine. I believe that let's see. 54.6% equity is the is included in the value line, Mr. Parcells' value line proxy group. Are
Correct. Yes.
Let's see. Now, the stipulation also adopted or proposes a 9.07% return on equity. Based on your expertise and your analysis of Palmetto, is that amount within the realm of reason? And if so, can you explain? Or if not, can you explain?
I believe it is at the, if we're speaking just about the cost of equity and no other aspects to the settlement, as for far as cost of equity is concerned, I believe it's on the low side.
Okay.
Excuse me, my battery's running out. I'm just plugging in my computer here. Okay, I'm sorry, I'm back.
Okay, do I need to repeat my question? Or were
No,
you?
I was, no, I think it's on the low end of reasonableness. But I do recognize and believe that, you know, that number is a reflection of other aspects of the settlement. I mean, in a settlement, nobody wins, everybody loses. I mean, that's my view of any settlement. I'm not saying in this particular settlement. And when I mean everyone, I mean the parties. So if all the parties are losing, then it's probably fair.
Thank you for your testimony today. I appreciate your appearance and your testimony. Thank you very much.
Thank you.
Thank
Commissioners,
you, man. You have a good day.
Commissioners, other questions?
Mr. Chairman.
Yes, who was that?
Irvin.
This is Commissioner Urban.
Commissioner Urban, go ahead.
Thank you, sir. Mr. Walker, I'm going to ask you to turn to page 3 of your direct testimony, please. Can you turn to page 3 of your direct testimony?
A moment. Yes, I have it.
You state, quote, with complete certainty, end quote, the value of CIAC related to Palmetto, Richland County LLC's 2013 acquisition of assets owned and operated by the city was zero and should be carried on the books of Palmetto Utilities as zero. Given the
Yes.
testimony from other witnesses, including those from Palmetto Utilities, that the county records from the city of Columbia were at best sparse, how can you be so certain that the value should be zero?
Well, I look at 3 instances. I looked at legally they didn't have title to the plant that the CIAC would have been financing. So they had never had title to the plant. Economically, the company never received the proceeds, or the, you know, if it were cash proceeds of CIAC. And then third, I look at it from a regulatory perspective, and that is the CIAC would not have been used and useful at that point in time of acquisition. So I looked at 3 tests, and it passed all 3 tests.
The records from the City of Columbia's bond issuance documents and its annual reports from 2005 to 2013, which is the year that Palmetto purchased the assets in the city, show the capital contribution to the city's water and sewer account totals slightly more than $70 million. Can you say with complete certainty that none of that $70 million in capital contributions should be recorded as contributions made to construction for Palmetto?
I can say with certainty there's no there is no means of doing so. In other words, the records don't exist. The city doesn't have the records, and none of the witnesses have been able to develop any type of records. I mean, the city, like other municipalities, do not have very good records. It's just sort of the nature of the beast.
So are you just saying you arbitrarily assign a number?
No, I'm not saying you arbitrarily assign a number. You need to assign, if you're going to assign a number, you need to assign it based upon some evidence, and no evidence exists. The city couldn't provide it, no witness, and when I say no witness, I mean all the parties involved couldn't really develop any information in support of the CIAC. I will note that even after the sale of the system, the CIAC still resides with the city. In other words, if you look at their future bond offerings, their CIAC didn't change when they sold the system. So they didn't pass off a piece of the CIAC to Palmetto. Whatever CIAC the city had, they retained.
So what's to prevent a scenario where a purchaser goes out and buys a municipal asset and then arbitrarily assigns a value to it after the purchase, and then asks the commission to put it in rate base?
Well, there's a couple of things that commissions can do, and that's look at the end result. You know, are the rates reasonable? Another thing that they could look at, which I don't know that anyone has done here, is to look at the plant value per customer and determine if that's, you know, reasonable given the vintage of the plant.
But you weren't asked to do that, right?
No, sir.
Could you have done that analysis?
Yes, you could take plant value and divide it by customers, and that would give you an indication of the original cost per customer.
Do you have the numbers to plug into that formula?
I don't have them offhand, but I know roughly 18 million is my recollection of the original cost less depreciation that's shown in the company's filing, and I believe there were a little over 11,000 customers. So you would take 18 million and divide it by 11,000, which is, you know, ballpark 1,500 to 1,600 per customer.
What does that number tell you?
That it's not an inflated number. I'll tell you that. It's not a. I've seen. I do a lot of work in Pennsylvania, and I've seen numbers as in the teens per customer. In other words, 15, 16,000 per customer, as opposed to here we're talking about a number which is about 1/10 of that number. So, you know, I know it's not excessive. I just don't know if it's, you know, the precise exact number that I think you're searching for. But it's a reasonableness number that I think, you know, you can judge by looking at it.
Those are all the questions I have. Thank you.
Thank you, Commissioner Urban.
Sir.
Thank you. Any other questions, commissioners?
Mr. Chairman.
Commissioner Whitfield.
Mr. Chairman. Yes, sir. That was me, I think, trying to chime in about the time of Commissioner Urban. I've just got one follow-up to Mr. Walker, and Commissioner Urban was kind of all over it. Mr. Walker, I asked Mr. Dade some questions yesterday. I don't know if you were able to see and hear all of that okay, but one of them he punted to you, and it has to do with what Commissioner Urban was just asking you along those lines about the records from the City of Columbia from 2005 to 2013, in which show capital contributions to the city's water and sewer account totaling more than 70 million. I think I know the answer to this from what all you've been saying, but just for the record, do you know, since Mr. Dade didn't know and said that you probably would, do you happen to know what percentage of those contributions were to the city's sewer system?
No, sir. The financial information from the city didn't differentiate between water and sewer.
All right. Thank you, sir. That's all I have, Mr. Chairman.
Thank you, Commissioner Whitfield. Commissioners, any other questions? Okay, any redirect, Mr. Hafer?
Just briefly, Mr. Chairman. Mr. Walker, Commissioner Irvin was asking you a couple of questions, and I wanted to go back and focus on some of those. Am I not correct that your opinion was as to the value of cash CACs?
Yes.
And by cash CACs, you are referring to the plant expansion fee that the City of Columbia charged to new customers, correct?
That is correct.
And your testimony is that the city would have kept that cash because there was no transfer of cash in the asset purchase agreement. Is that correct?
That is correct.
Thank you. I don't have anything further, Mr. Chairman.
Thank you. Any recross on that question? Okay, hearing none. Mr. Walker, we thank you for your testimony. Thank you for being here, and you may step down.
Mr. Chairman, may I ask that Mr. Walker be excused?
Yes, Mr. Walker may be excused.
Thank you.
Okay, it's 12:30, so we're going to take a break for lunch. We'll be back at 1:43, and we are
Thank you.
in recess.
Thank you.
Hey, welcome back, everyone. We'll call ourselves back into session. Before we begin, we'll roll call for all the commissioners. Vice Chair Belser.
Present.
Commissioner Whitfield.
Here.
Commissioner Hamilton.
Here.
Commissioner Howard.
Here.
Commissioner Urban.
Here.
Thank you. All right. So we are, Mr. Hafer, I believe we're to witness number 9.
Mr. Chairman, this is Jenny Pittman for ORS. May I ask a quick procedural question?
Certainly.
Just for our planning purposes, we were wondering what time the commission intends to end the proceeding this afternoon. I think the invitation said 4:15.
We've been going pretty slow. I might go a little closer to 5 if we can. I think we have the live stream and Segra and everybody else booked till 5. So if we can, will that work for y'all if we go to a 4:45 or a little after?
Yes.
Okay.
That works for us. Thank you.
Okay. Thank you. Anything else we need to do before we begin? Okay, Mr. Hafer.
Thank you, Mr. Chairman. Just one housekeeping matter. I would ask that Mr. Walsh be excused. I failed to do that. He's now gotten his free lunch out of me, and so I don't see any reason for him to remain here in my office.
I don't see him in the picture. I figure he's already on the road. He's excused. Mr. Walsh is excused.
Thank you, Mr. Chairman. The applicant would call William Crawford.
Okay, we have Mr. Crawford's picture. Mr. Crawford, if you will raise your right hand, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And let's make sure we got your microphone or your phone on, because we didn't hear that. I do. And Carlos, are we on with him? With Mr. William Crawford?
Carlos, he was where
I don't see him
Mr.
connected
Walsh,
on the phone.
he's where Mr. Walsh was at.
Okay, opening that line.
Okay. Let's try him again. Mr. Crawford, try now. I think you may be open.
I do.
Gotcha. Thank you. That worked great. All right, Mr. Hafer.
Thank you, Mr. Chairman. Would you please state your full name and business address for the record?
Yes, William Perkins Crawford, Jr., business address is Packlet Milliken, 550 South Main Street, Suite 601, Greenville, South Carolina.
Mr. Crawford, where are you employed and in what capacity?
I'm the CEO of Packlet Milliken, which is the indirect parent of Palmetto Utilities.
Did you cause to be pre-filed in this testimony, in this case, direct testimony consisting of 4 typewritten pages?
I did.
Do you have any changes, additions, deletions, or corrections to that pre-filed testimony?
I do not.
If I were to ask you the questions set forth in the typewritten pre-filed testimony, would your answers from the witness stand today be the same as printed therein?
They would.
Chairman, I'd ask that Mr. Crawford's direct pre-filed testimony be copied into the record as if given.
Mr. Crawford's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Crawford, did you also cause to be pre-filed rebuttal testimony consisting of 7 pages?
I did.
Do you have any changes, deletions, or corrections to that testimony?
I do.
Would you give those now?
Yes. On page 2, delete lines 1 through 12. Continuing on page 2, line 18, beginning with the word I through line 26, please delete that. Again on page 2, please delete line 28 through line 32. Delete the entirety of page 3. On page 4, please delete lines 1 through 8. Again on page 4, beginning on line 25, starting with the word if,
please delete through line 31. And then on page 5, please delete lines 1 through 17.
And Mr. Walker, those deletions are the same as reflected in the stipulation paragraph 17A.
Crawford, Walker? Yeah. Yes. I think you said Walker, but anyway.
I'm sorry, Mr. Crawford. I apologize. Too many Walkers. Mr. Chairman, Mr. Crawford is available for cross-examination by the parties and questions from the commissioners.
We're going to enter his rebuttal testimony with the...
I'm sorry if I failed to do that.
Yes, sir.
I would move that his rebuttal testimony with those changes.
Okay, Mr. Crawford's rebuttal testimony as amended will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman.
Okay, now we're ready for cross. Mr. Hafer.
Yes, Mr. Crawford, if you would please answer any questions counsel for the consumer advocate or the commissioners may have.
Okay, thank you. Mr. Hall.
I have no questions for Mr. Crawford.
Thank you. Commissioners.
Mr. Chairman, Commissioner Hamilton has a question.
Commissioner Hamilton.
Thank you, sir. How are you today, Mr. Crawford? Happy to have you with us, sir.
Thank you.
Mr. Crawford, ORS witness Lloyd states that on page 18, lines 6 through 9 of his direct testimony, that if PUI is allowed a return on the PRC plant investment, customers would be effectively paying twice. What do you have to tell us about that?
Yeah, I definitely don't think they would be paying twice. I don't think there was any real relationship between what the city of Columbia paid and what charged and its actual costs. You know, I think they may have paid for a baseball stadium, but I don't believe that they paid for these assets twice. I do not, sir.
Okay. In other words, you do not feel that they contributed when they were for the city and to you?
Yes, sir, that is correct. They did not. And in fact, a lot of what they contributed reference to plant expansion fee, and we didn't buy plant.
What did what work diligence did your company do to perform to determine how much of the plant was donated, if it was donated?
It was a predecessor company, but in connection with this rate case of the prior witnesses of PUI have done a great deal of diligence, and I think they are very consistent in their view that we did not receive the benefit of the cash CIAC paid by the former PRC customers.
Okay, did CIAC factor have any direct influence on the price you paid for the facility?
I don't believe so. But then again, that was a predecessor company, so I don't know what was in their head, but it was. I don't believe it did.
Okay, on these type of investments, you don't feel like it was fair for the customers to have to pay twice?
It would not be fair for the customers to pay twice, no, but I don't believe they did.
All right. Thank you, sir, very much.
Yes, sir.
Thank you, Commissioner Hamilton. Commissioners, any other questions? All right, Mr. Hafer, any redirect?
No redirect, Mr. Chairman.
Thank you. Mr. Crawford, thank you for being here, and we appreciate your testimony, and you may step down.
Thank you very much.
Thank you. Okay, Mr. Hafer.
Mr. Chairman, that concludes the applicant's case.
Okay, thank you. Thank you, Mr. Hafer. Okay, we'll move on to the South Carolina Department of Consumer Affairs. Mr. Hall.
Yes, we have Aaron Rothschild. Get him on.
We'll get Mr. Rothschild on the screen. Okay, Mr. Rothschild, welcome. If you will raise your right hand, we'll swear you in. do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Let's make sure we got, I saw your mouth move, but did you hear him? I mean, can you hear him? Operator, let's get Mr. Rothschild, his line up. Sorry, I forgot about that. Okay, do we have Mr. Rothschild connected now? Mr. Rothschild, try to say "I do" one more time, and let's see if we've got you.
I do.
Got you. Thank you. Okay, Mr. Hall.
Thank you. Mr. Rothschild, would you please state your full name and business address for the record?
My name is Aaron Rothschild. My business address is 15 Lake Road in Ridgefield, Connecticut, 06877.
And by whom are you employed and in what capacity?
Rothschild Financial Consulting, and I'm a partner.
Did you prepare or cause to be prepared 22 pages of testimony for this docket titled Direct Testimony of Aaron L. Rothschild Accounting, which was filed on May 26, 2020?
That's correct.
Did you also prepare or cause to be prepared 80 pages of testimony for this docket titled Direct Testimony of Aaron L. Rothschild Cost of Capital, which was also filed on May 26, 2020?
Yes, I did.
And did those testimonies include 51 pages of exhibits enumerated ALR1 through ALR7, which were also filed on May 26, 2020?
That's correct.
Did you also prepare 17 pages of surrebuttal testimony, which was filed for this docket on June 16, 2020?
That's right.
I believe you submitted an errata sheet, which was filed on July 8th, indicating that Table 7 in your cost of capital direct testimony contains some incorrect numbers. Is that correct?
That's correct.
Other than that errata sheet, do you have any changes or corrections to your testimony?
No, I do not.
Let me ask you one thing. Was there a change on, I believe, on page 6, line 6, regarding some figures in the table that were potentially incorrect on the errata
yes,
sheet?
that's correct. That's correct. Sorry. That in the errata it said that the number on page 6, line 6, needed to be changed from $2.5 million to $1.5 million, but the $2.5 million was correct, so it should remain. And there's a table that needed to be the numbers in the table needed to be changed.
And could you address what those changes are now, please?
Yes, in Table 4, it should change from $1,544,396 to $2,472,109, and additionally, the $13,175,016 should be changed to $12,247,304.
Thank you. Other than those revisions in your testimony, if I had asked you the same questions today, would your answers be the same?
Yes.
Mr. Chairman, I would move to have the pre-filed direct and surrebuttal testimonies of Mr. Rothschild moved into the record as if given orally from the stand.
Mr. Chairman, may I make inquiry, please? Would it be
Yes, sir, Mr.
appropriate for Mr. Rothschild to go to the pages of the testimony he corrected and actually read us the corrections? In other words, he said they were in the errata sheet. The other witnesses have actually given us all the corrections that they had. We do have an errata sheet, but would it be appropriate for him to read his corrections?
Okay, we can go back to that. Can we do that, Mr. Rothschild, to read the corrections on the errata sheet?
Yes. So you would like me to read the portion of my testimony that refers to these numbers and how they are changed?
Yes.
Yes, that will be fine.
On page 6, lines 5 to 7, my testimony says, if Mr. Walker's rate of return recommendations are adopted instead of mine, consumers will pay close to $2.5 million more per year. In the errata sheet, that was changed to $1.5 million, but the correct number is $2.5 million as shown in my direct testimony. Below line 7, between lines 7 and 8, there's a table 4 titled Annual Revenue Impacts Comparison, Rothschild and Walker. The figure in the row Rothschild in the testimony has $13,175,016. The correct number is $12,247,304. The next line is titled Walker, and the number the 1,544,396 should be changed to $2,472,109. And those are all the corrections.
Okay. Go ahead.
Mr. Chairman, may I ask through the chair to Mr. Hall and Mr. Rothschild, we had also on the errata sheet, there's a indication that there were some changes in Table 7, page 14 of 80. Is that correct?
Yes, those remain correct.
Okay. In Table 7...
we would be happy to submit.
Mr. Chairman, this is John Hafer, if I might.
Yes, sir.
I think there's some confusion. The errata sheet references Table 7, page 14, and there's no Table 7 on page 14. I think it probably should be page 12, and then on the errata sheet says page 8, and I think that should be page 6.
Mr. Butler, it's referencing the watermark on the side of the page that's printed when it's filed with on the DMS. Instead of the page number at the bottom of the page, it's referencing the watermark that is put on the document when it's filed on the DMS as the page.
Yes, ma'am. I was just trying to get clarity as to his changes. I know the listed Mr. Hafer's just mentioned that he thought that the page numbers were different and tables were different.
And the page numbers referenced on the errata sheet are the page numbers on the watermark on the side of the page that are placed by the DMS and not on the bottom of the page that were put in there when the testimony was prepared.
Okay, thank you. I now understand.
That's correct. And if you all would like, we would be happy to submit a revised Table 4 showing those revisions, much as we did on the errata sheet for Table 7.
Okay, hang on. We need, Ms. Wheat says we need to read in. Okay, Ms. Wheat, it says we need to read in each one of these from Table 7, page 14 of 80. So read the actual line. Please change 2014 to 2018. But we need for him to read these. Okay, so that it will be under oath. Okay. So, Mr. Rothschild, we can get you on that first page where it says Table 7, page 14 of 80. If you would please read, so we'll have these in the record, those changes that you have, starting with please change 2014 to 2018.
Okay, I see. Yes, I need to get the numbers in front of me. Excuse me.
Aaron, I just sent it to you.
You did? Okay, thank you.
It's basically just what you have on the first page of your errata sheet, right there under where it says Table 7, page 14 of 80. Those, there are 1, 2, 3, 4, 5, 6, 7, 8 lines. It says, please change. We just need you to say those on the record.
Okay, well, I'm just gonna bring up the errata sheet and I'll read those in. Okay, I have them now.
Right.
So on Table 7 Table 7 in my direct testimony, in the original testimony, it read 2014. That should be changed to 2018. 2015 should be changed to 2017. 2016 remains the same. 2017 is changed to 2015, and 2018 is changed to 2014. The first two columns, all the numbers remain the same. For the 2016 column, the 30% should be changed to 31.2%. The 70% should be changed to 68.8%. And in the column titled average, the top row should be changed from 27.7% to 28%. And the column titled long-term debt should be changed from 72.3% to 72%.
Okay, that's got it. Everybody got where we are, Mr.
The only
Butler.
thing I would ask, Mr. Chairman, if you please, through the chair, if they could submit corrected copies of these, I would appreciate it greatly.
Okay.
Thank you.
Can we have that done?
Of course.
Thank you. Okay, are we ready? So we have not, we've not put anything in yet, so, okay. So go ahead, Mr. Hall. Sorry.
Thank you. With those changes, I would move to have the pre-filed, direct, and rebuttal testimonies of Mr. Rothschild moved into the record as if given orally from the stand.
Okay, Mr. Rothschild's pre-filed, direct, and rebuttal testimony will be entered into the record as though given orally from the stand.
I would also move to have his exhibits entered as the next applicable hearing exhibits.
Okay, and his exhibits as corrected, is that proper, Mr. Butler, Ms. Wheat? There were no changes? Okay, I thought we had some changes there. All right, the exhibits ALR 1 through 7 will be entered as hearing exhibit number 14.
And Mr. Chairman, Mr. Rothschild has prepared a summary of his testimony if the commission will allow.
So you have additional testimony? I thought you'd already made reference to additional testimony. Is that correct?
No, sir. I'm just saying Mr. Rothschild has prepared a summary of his testimony if the commission will allow him to present it.
Yes, sir, but I'm just trying to discern, you had additional testimony as well for Mr. Rothschild, correct? No? Okay, one's marked cost of capital, one's marked accounting, from what I can see. You have two separate.
Yes, I believe we addressed
both are rough. All right, I apologize. Thank you. Go right ahead.
Okay.
Do apologize.
Okay, go right ahead.
Mr. Rothschild, please deliver your summary of your testimony.
I'm testifying on behalf of the South Carolina Department of Consumer Affairs. My direct testimony provides my recommendations to the Public Service Commission of South Carolina regarding the following 3 issues. Number 1, rate of return, appropriate cost of equity, capital structure, and overall cost of capital for Palmetto Utilities, Inc. Number 2, Tax Cuts and Jobs Act, the appropriate adjustment to reflect the effects of the TCJA. Number 3, City of Columbia Sewer Collection System Acquisition, the appropriate regulatory treatment of the $18 million acquisition of sewer collection system from the City of Columbia. Rate of return. I recommend an overall cost of capital rate of return of 7.1% to 7.56%, averaging 7.33%, be used to calculate PUI's revenue requirement and ultimately its consumer rates. My rate of return recommendation is the weighted average cost of the following two components: the cost of equity, or ROE, of 8.2% to 9.07%, averaging 8.63%, and a cost of debt of 5.89%. The cost weighting is based on my recommended capital structure of 52.5% equity and 47.5%, which is derived from the average capital structures of the proxy group and discussed in my testimony. PUI's witness, Harold Walker, recommends an 8.57% rate of return, a 10.50% cost of equity, and a capital structure containing 58.21% equity and 41.79% debt. We recommend the same cost of debt, 5.89%. Mr. Walker's rate of return recommendation, if adopted, would require consumers to pay about $2.5 million more annually than if my recommendation was used to set rates. Mr. Walker's 10.5% cost of equity recommendation is above the return expectations published by Charles Schwab, 6.5%, and J.P. Morgan, 7.2%, for the overall long-term U.S. stock market as of March 2018, which includes primarily riskier, unregulated companies. My recommendations will allow PUI to raise capital on reasonable terms while fulfilling their obligation to provide safe and reliable service. My recommendations satisfy the requirements of Hope and Bluefield that regulated utility companies should have an opportunity to earn a return commensurate with returns on investments in other enterprises having corresponding risks. I use current capital markets, e.g. stocks, bonds, options, as much as possible because it measures investors' expectations directly instead of relying solely on historical data and analyst forecasts. My market-based cost of equity recommendation, 8.2% to 9.07%, is superior to a cost of equity recommendation based on historical data, non-market-based, because, among other reasons, the cost of equity that PUI has to pay investors is based on capital markets. Cost of equity in today's financial market. It is always critical to consider the results of cost of equity models in the context of financial markets in general. It is particularly important to consider market data in the current economic environment because the spread of COVID-19 has drastically increased the speed and intensity of financial market change. In the first half of March 2020, stock prices crashed and recovered to some degree. Unemployment will likely skyrocket, and global growth is expected to slow or even shrink for the remainder of 2020 and possibly longer. In response, the Federal Reserve has cut short-term Treasury yields to 0%, and Congress has passed a $2 trillion stimulus package. Table 2 of my direct testimony shows a summary of how COVID-19 has impacted financial markets between December 31st, 2019, and April 28th, 2020. The yield on 30-year Treasury bonds has declined from 2.39% to 1.2%. The yield spread between BBB rated bonds, BAA, rated corporate bonds, and 30-year U.S. Treasury bonds has increased by 145 basis points. Market risk premiums and investors' volatility expectations have increased significantly. Water utility stocks have been impacted along with the overall market, but as you might expect for companies providing essential services, they have been impacted considerably less than the overall market. As shown in the table, the option implied or forward betas of water utility stocks have declined substantially through the recent crisis. This indicates that their cost of equity may not have been impacted as much as other companies that rely on earnings from selling products consumers can do without during a crisis. Water utilities' earnings are relatively stable during an economic slowdown because they provide essential services. This stability indicates the cost of equity is likely relatively stable because their earnings are safer than those of an average company during an economic downturn. As shown in Chart 1 of my direct testimony, the average earnings per share of the companies that make up the S&P 500 fell nearly 80% during the financial crisis of 2007 to 8, while the earnings of water utilities remain relatively stable. The stability of water utility earnings during crises indicates water utility companies will likely be able to raise capital on reasonable terms before other companies and at a lower cost. Cost of equity calculations. To arrive at my recommendations, I applied the following three models to a water proxy group of 7 publicly traded water companies selected by PUI witness Harold Walker. 1, constant growth discounted cash flow model. 2, non-constant growth DCF model. And 3, capital asset pricing model. My DCF model is used by major financial institutions and recommended by leading financial textbooks. My CAPM is based on methodologies used by Value Line, the Chicago Board of Options Exchange, and published in peer-reviewed academic journals. I use the sustainable growth form of the DCF model as recommended by leading textbooks to calculate the cost of equity for regulated utility companies because it is more reliable than mechanically adding an analyst earnings per share growth rate to the dividend yield. The sustainable growth rate maintains the mathematical relationship between earnings, dividends, book value, and stock price that must be respected. The non-constant growth form of the DCF model determines the return an investment expected by investors based on an estimate of each separate annual cash flow the investor expects to receive. For the purpose of this computation, I've incorporated Value Line's detailed annual forecast to arrive at the specific non-constant growth expectations that an investor who trusts Value Line would expect. The CAPM relates return to risk. Specifically, it relates the expected return on investment in a security to the risk of investing in that security. The riskier the investment, the greater the expected return, i.e. the cost of equity. Investors require to make that investment. The equity risk premium component of my CAPM is based on investor expectations as indicated by prices of stock options traded on the S&P 500. My response to Mr. Walker's rate of return testimony. Mr. Walker uses 3 cost of equity models, but he does not implement them correctly. Mr. Walker's DCF model is flawed because he does not consider if his growth rate component is sustainable. His CAPM analysis is flawed because he uses non-market-based risk-free rate and a risk premium component based, in part, on an average of short-term returns 1 year, instead of appropriately considering long-term returns. Mr. Walker's risk premium method is not reliable because, among other reasons, he increases his risk premium from 4.7% to 5.7% based on his false claim that risk premiums and interest rates are inversely correlated. As a result of this, Mr. Walker's 10.5% cost of equity and 8.57% cost of capital recommendations significantly overstate PUI's market-based cost of equity. If his recommendations are used to set rates, consumers will be significantly overcharged. I'm particularly concerned with the 2 adjustments Mr. Walker adds to his cost of equity model results. These adjustments are large. His financial risk adjustment adds 0.90%, and his investment risk adjustment adds 0.40% to the average of his cost of equity models. Together, these adjustments increase his cost of equity results by more than 14%, from 9.2% to 10.5%. Mr. Walker's 0.90% financial risk adjustment is not supported by finance and attempts to counteract the established regulations of which investors are well aware. Mr. Walker claims that because the market value cost of equity is applied to book value, rate base to set rates, an adjustment is required when stock market prices and book value are not similar. Currently, the market prices of water utility stocks are more than 300% larger than their book value, resulting in a market-to-book ratio of more than 3. This is the case for all water utility companies, and there is no reason to think that PUI's market-to-book ratio would be significantly different if it had publicly traded shares. Established regulatory principles require applying a market-based cost of equity to book value. By recommending the financial risk adjustment, Mr. Walker is implying that investors forget how regulation works after each rate case. Investors understand that as part of the regulatory process, allowed returns are applied to book value. This is a process that has been going on for decades, and it is hard to argue that investors are not aware of this. Mr. Walker's 0.40% investment risk adjustment should be rejected because it contradicts financial theory, among other reasons. Mr. Walker claims the risk that investors can eliminate through diversification impacts PUI's cost of equity. Mr. Walker concludes that PUI's lack of economic diversification, among other risks, indicates that PUI's cost of equity is higher than the companies in its comparable group. However, an investor is unlikely to require a higher return to invest in a company with only regional economic exposure because investors can attain economic diversification by purchasing a portfolio of stocks of companies doing business around the country and the world. Tax Cuts and Jobs Act. I recommend the Commission order PUI to refund ratepayers the accumulated excess deferred income taxes they collected as a result of the passage of the TCJA. Regarding how this money is returned to consumers, I recommend the Commission follow IRS requirements regarding normalization and flow-through. Within the spirit of the use of normalization accounting, ratepayers are entitled to the benefits of the deferred taxes they were paying since the January 1st, 2018 tax law change. Refunding consumers excess deferred income taxes, EDIT, is not retroactive rate making as PUI claims because PUI does not own these funds. These are funds that were collected from ratepayers to pay taxes at a rate which PUI will not pay. Consumers should receive a refund equal to the EDIT collected by PUI as a result of the TCJA. The acquisition. I recommend that $1.29 million of the $18 million acquisition price be allowed to go into PUI's rate base. I'm recommending that $1.29 million of the acquisition price be included in rate base because GDS Associates, Inc. identified $1.29 million of plant book values known to be non-contributed in the city's accounting records. PUI has the burden of proof, and they did not provide an alternative estimate of how much of plant was built with non-contributed funds. PUI's primary position is that the entire $18 million acquisition price should be allowed in rate base. This justification for this position includes the following. 1, the amount paid by the first utility to own an asset is the original cost. 2, the amount of CIAC is unknowable because the city kept poor accounting records. And 3, most of CIAC was used to build assets, e.g. cities Metro WWTP, not purchased by PRC. PUI witness Mr. Walsh's justification for recommending inclusion of the entire $18 million is based on his reading of USOA, Instruction 18. Regardless of the accuracy of Mr. Walsh's claims regarding USOA, the Commission does not have to mechanically set rates based on USOA instructions. The Commission has the authority, and I will argue the obligation, to set rates that are just and reasonable. Regarding the city's poor record keeping, PUI has the burden of proof, and the fact that the city kept poor accounting records does not justify PUI or the city taking ownership of CIAC. PUI only relies on its reading of the USOA and has not met its burden of proof that there was no CIAC. Regulatory principles require CIAC to be accounted for and not be allowed in PUI's rate base. The appropriate amount that should be included in PUI's rate base is no more than the amount that would be appropriate to add to rate base if the acquired entity was a regulated utility. and other treatment would be any other treatment would be extremely unfair to ratepayers. Original cost rate making is based on the principle that items added to rate base that are used and useful and have been prudently incurred as a reasonable cost should be added to rate base in an amount equal to the depreciated original cost with appropriate adjustments for assets acquired by CIAC and deferred income taxes. Setting rates as if CIAC funds were an investment made by PUC or the city is unfair to consumers who made those contributions to existing consumers who would be asked to cover those costs once again. Conclusion. Based on the evidence presented in my testimony, I conclude that the cost of equity allowed for the company should be between 8.2% and 9.07%, averaging 8.63%, with an overall cost of capital between 7.1% and 7.56%, averaging 7.33%. Mr. Walker's cost of equity recommendation of 10.5% is unreasonably high, primarily because he adds inappropriate adjustments for company size and the difference between market value and book value capital structure. His adjustments should not be accepted because they are against original cost rate making. My 8.2% to 9.07%, averaging 8.63%, cost of equity recommendation satisfies the requirements of Hope and Bluefield that regulated utility companies should have the opportunity to earn a return commensurate with returns on investments in other enterprises have a corresponding risk. My recommendations are consistent with legal standards set by the United States Supreme Court and market data. My cost of equity and an overall cost of capital recommendations will allow PUI to raise capital in reasonable terms while fulfilling their obligation to provide safe and reliable service. That concludes my testimony summary.
Thank you, Mr. Rothschild. Please answer any questions that other counsel or the commission may have.
Okay, thank you. Cross-examination, I think the order we go in is ORS first. Ms. Pittman.
No questions from ORS.
Okay, thank you. Mr. Hafer from the company.
No questions, Mr. Chairman.
Thank you. Thank you. All right, commissioners. Okay, hearing none, Mr. Rothschild, thank you for your testimony, and we appreciate you being here, and you may step down.
Thank you. And Mr. Chairman, I ask that Mr. Rothschild be excused.
Yes, sorry. Yes, Mr. Rothschild may be excused. Thank you.
Thank you.
Okay, Mr. Hall, that's Mr. Rothschild is your only witness?
Yes, Mr. Chairman, that concludes our case.
Great, thank you. Okay, Ms. Pittman, Office of Regulatory Staff. Mr. Nelson,
sorry, I'm muted.
There you go.
Yeah, I'm sorry, I didn't take myself off mute. ORS would call as its first witness Mr. David Parcell.
Your line is
Operator, Mr. Parcell.
Yes.
There he is. Okay, Mr. Parcell, if you'll raise your right hand, we'll get you sworn in. You solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you.
Good afternoon, Mr. Parcell. Could you please state your full name and occupation for the commission?
Yes. My name is David C. Parcell, P-A-R-C-E-L-L. I'm an economist and a principal of Technical Associates Incorporated.
Thank you. And are you the same David Parcell who pre-filed 51 pages of direct testimony in this case on May the 26th of this year?
Yes.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
No.
And if I asked you those same questions today, would your answers be the same?
Yes.
Thank you, Mr. Parcell. Mr. Chairman, ORS asks that the pre-filed direct testimony of Mr. Parcell be entered into the record as if given orally from the stand.
Mr. Parcell's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Parcell, did you also prepare or cause to be prepared two exhibits labeled DCP-1 and DCP-2, which were filed with the commissions as attachments to your pre-filed direct testimony?
I did.
And do you have any changes or corrections to those two exhibits?
No.
Mr. Chairman, ORS asks that exhibits DCP-1 through DCP-2 attached to Mr. Parcell's pre-filed direct testimony be marked and entered into the record as the next hearing exhibit.
Mr. Parcell's pre-filed direct exhibits DCP-1 and DCP-2 will be entered as hearing exhibit number 15.
Thank you, Mr. Chairman. Mr. Parcell, did you also pre-file 15 pages of surrebuttal testimony in this case on June 16th of this year?
Yes.
Do you have any edits, changes, or corrections to your pre-filed surrebuttal testimony?
No.
Thank you, Mr. Chairman. ORS asks that the pre-filed surrebuttal testimony of Mr. Parcell be entered into the record as if given orally from the stand.
Mr. Parcell's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Parcell is now available for questions from either the consumer advocate or from the commissioners. Thank you.
Okay, thank you. Okay, Mr. Hall.
No questions. Thank you.
Thank you, Mr. Hall. Commissioners.
Mr. Chairman, Commissioner Hamilton.
Commissioner Hamilton.
Thank you, sir. Mr. Parcell, happy to see you with us today, sir.
Thank you. Happy to be here.
Mr. Parcell, in your direct testimony concerning the rate of return on page 3, line 1, your recommendation was a little different than the company. You had a 55% equity and 45% debt. The one that characterized Palmetto Utilities in the case is 58.21% equity and 41.79% debt. Why, Mr. Parcell, do you believe that the company's proposed capital structure is not appropriate for this case?
Actually, two reasons. The first reason is that whereas it's true that as of the end of the test period, August 31, 2019, their capital structure contained about 59% equity, their capital or their equity ratio has jumped substantially around over the years. For example, on Exhibit DCP-2, Schedule 3, page 103, I show a company's capital structures from the period 2014 up through August 31, 2019. The equity ratio has been as low as 42.2% and as high as 63.7%. So it moved a lot from year to year. At the end of calendar 2018, the equity ratio was 49.5, less than 50%. Yet 8 months later, on August 31st, it was 57.8%. So it's quite volatile and sort of a moving target in that regard. And as I just indicated a moment ago, in the test period, equity ratio was near a high point. And the second reason I say it's not appropriate is a substantial portion of this company's debt is loans from affiliated companies. In other words, it's what they can want it to be at any given point in time. And I'm not saying anything bad about what they're doing. I'm just saying it's not a market capital structure. It's to be created. It has been created. And again, I'm not saying created anything mean or improper about it, but it's not a market capital structure. So I think it's proper to use a capital structure representative of the equity ratios of the companies and proxy groups, which is 55%, and I think the stipulation is 54.6%. So
Yes.
practically the same thing.
Thank you, Mr. Parcell. I appreciate the testimony, sir. Thank you,
Thank
Mr.
you.
Chairman.
Thank you, Commissioner Hamilton. Commissioners, any other questions? Commissioner Belzer.
Good afternoon, Mr. Parcell.
Good afternoon.
I want to follow up just on what you just responded to Commissioner Hamilton with. Can you elaborate on why this proposed capital structure and the stipulations of, I believe, 54.6% equity, 45.4% debt is appropriate?
Well, really for the same reasons as my recommendation, because my recommendation in this case was a common equity ratio of 55.0%, and 50.6% is very close to that. So insofar as a 55% equity ratio would be appropriate, I think 54.6 would almost equally be appropriate.
And is that based on any of your, what are you basing that on? Any particular model, your expertise, your experience? Tell me.
Some of each of those. For example, I just mentioned a few minutes ago about the fact that the company's equity ratio has been quite volatile over time. I also mentioned the fact that a substantial portion, over 50% as a matter of fact, of his debt is advances from affiliated companies. And as I show on my DCP-2, Schedule 4, the average equity ratios of the proxy companies over the last 5 years has been about 55%. And the prospective equity ratios over the next 4 or 5 years is about 56%. So those numbers are compatible with the water industry itself, and it is the water industry that I'm using to estimate the cost of equity, so there's a matching there.
Thank you very much.
Thank you, Commissioner Belzer. Any other questions, commissioners? Okay, thank you. Mr. Nelson, any redirect?
No redirect, Mr. Chairman. We would also ask, please, that Mr. Parcell be excused.
Thank you. Mr. Parcell, thank you for being here with us today. You may step down and be excused.
Thank you.
Okay, we can go for the next ORS witness.
Mr. Chairman, ORS calls next witnesses Ms. Dawn M. Hipp.
Okay, welcome, Ms. Hipp. We'll get you to raise your right hand. And do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Hipp, would you please state your name and occupation?
My name is Dawn M. Hipp. I'm the Chief Operating Officer with the Office of Regulatory Staff.
And are you the same Dawn M. Hipp who pre-filed 6 pages of direct testimony in this case dated May 26, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed direct testimony?
No, I do not.
If I ask you the same questions today, would your answers be the same?
Yes, they would.
Mr. Chairman, ORS asks that Ms. Hipp's direct testimony be entered into the record as if given orally from the stand.
Ms. Hipp's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Are you also the same Dawn M. Hipp who pre-filed 13 pages of surrebuttal testimony in this case on June 16, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed surrebuttal testimony?
Yes, I do.
Are those changes or corrections listed on an errata sheet filed on July 6, 2020?
Yes,
Can you walk us through those changes?
certainly. On page 12
of 13, line 16, please replace the number 1,321,512 with the number 1,341,028. On page 12 of 13, line 17, please replace the following words. August 6, 2020, with the expected date of new effective rates of August 7, 2020, with the words August 20, 2020, with the expected date of effective rates of August 21, 2020. And finally, on page 13 of 13, line 1, please replace the following words. Open paren, $1.07, close paren, per ERC, open paren, 1,321,512 / 34,290 ERCs / with the words open paren $1.09 close paren per ERC open paren $1,341,028 / 34,290 ERCs /
Ms. Hipp, if I asked you the same questions today, would your answers be the same?
Yes, aside from the changes that I just mentioned.
Mr. Chairman, ORS asked that Ms. Hipp's rebuttal testimony with corrections indicated on the errata sheet and given orally be entered into the record if given orally from the stand. ORS also requests the errata sheet be made part of the record.
Okay, Ms. Hipp's pre-filed rebuttal testimony with the changes indicated on the errata sheet will be entered into the record as though given orally from the stand. And are we going to put the errata sheet in as an exhibit, or is that, do we need to? We'll just attach it to the testimony. Okay.
Thank you, sir. That's fine. Thank you. Ms. Hipp, did you also prepare or cause to be prepared 3 exhibits labeled Rebuttal Exhibit DMH1 through Rebuttal Exhibit DMH3, which were filed with the Commission as attachments to your pre-filed rebuttal testimony?
Yes.
Did you also prepare or cause to be prepared 1 exhibit labeled Revised Rebuttal Exhibit DMH4, which was filed with the Commission on July 6, 2020?
Yes.
Do you have any changes or corrections to your rebuttal exhibits or revised rebuttal exhibits?
I do not.
Mr. Chairman, ORS asks that Ms. Hipp's 3 exhibits labeled rebuttal exhibit DMH1 through rebuttal exhibit DMH3 and revised rebuttal exhibit DMH4 be marked for identification and entered into the record of the case as the next composite hearing exhibit.
Okay, Ms. Hipp's exhibits, I lost my place, DMH1 through DMH3 and revised exhibit DMH4 will be entered as hearing exhibit number 16.
Thank you, Mr. Chairman. Ms. Hipp is now available for questions from the parties or the Commission.
Thank you. Okay, Mr. Hall.
I have no questions for Ms. Hipp. Thank you.
Thank you, Mr. Hall. Commissioners.
Mr. Chairman.
Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Ms. Hipp.
Good afternoon, Commissioner.
Ms. Hipp, just a couple of questions, if I might, about your rebuttal testimony. On pages 10 and 11 of your rebuttal, you outline, and I'll give you a minute to get there.
I'm there.
Okay, on pages 10 and 11, you outline ORS's PRC asset alternative plan. Your alternative plan values the PRC assets at the company's original cost study using the Handy-Whitman indices, but the plan excludes the PRC asset from any calculations of rate base and return on rate base. Why did ORS exclude the PRC assets from rate base when the company paid for these assets and they are providing service to customers?
Thank you, Commissioner. In our alternative, let's start from the beginning. In our direct testimony, of course, we had a lower value for the PRC assets because our position is and remains that there was considerable amount of donated plant to the City of Columbia. Recognizing that this is a complex issue, what to do and how to value the PRC assets, which is an acquisition from a municipality. We looked at potential options, and we used the GDS report as a path forward. One of the recommendations of the GDS report was to consider recovery of the PRC assets that are currently used and useful to customers, but not allowing a weighted average cost of capital return to the company. And that is the impact that you see in our alternative. We felt and still feel that that is a reasonable compromise. As you're aware, we have entered into a stipulation with the company that does now, in our proposal, offer the company a return of and a return on the PRC assets valued at roughly $8.4 million.
Thank you, Ms. Hipp. Let me go just a little bit further with you along the same area of your rebuttal testimony. Also, again, around pages 10 and 11, where you discuss the PRC asset alternative. And, of course, you include a recovery of $10.7 million in net plant. How did ORS determine
Commissioner Whitfield, I think you've frozen up. Wait, hang on, Ms. Hipp, can you hear us? Because we can't hear you. I understand that. Operator, we have lost Commissioner Whitfield and Ms. Hipp. Do what? They can y'all hear us at all, Ms. Hipp, Commissioner Whitfield? Okay. Who's that? Commissioner Whitfield? Do we need to just take a recess? Okay, we'll take about 5 minutes and try to get this rectified, and then we'll go back to where we were. Okay, welcome back. I think we have our technical issues settled, and I believe that we are still in the middle of a question from Commissioner Whitfield, questioning Ms. Dawn Hip from ORS. So, Commissioner Whitfield, if you will continue.
Ms. Hip, I'm sorry, I'm going to ask you the second question again. I think is where we need to start. I think you had discussed the ORS's PRC asset alternative plan and with lack of some of the city records. But I'm going to go into the second question I asked you. I think they did get your answer to the first one in the record. So I'm just going to ask you the second one only, which was in your surrebuttal testimony. Again, we're around page 10 or 11 of your surrebuttal. You outline the proposed PRC asset alternative, which includes a recovery of $10.7 million in net plant. How did ORS determine that $25 million in plant and service and $14.7 million in accumulated depreciation should be recovered?
Certainly. The 10 million, roughly 10 million, 10.7 million in plant that you see in our PRC assets are determined to be, were determined by ORS to be the PRC assets with the correction for the Handy-Whitman indices. Since this is a compromise position offered in our alternative, that is the value that you see. The two numbers that you are asking about, the plant and service number of $25.4 million, less accumulated depreciation of $14.7 million, were determined by the ORS audit department, and those can be found in the testimony of ORS witness Cleckley and possibly ORS witness Sullivan. So I will allow them to answer as to how they calculated those numbers. Those numbers were calculated in coordination with ORS witness Chuck Loy, who will testify next.
And I believe I acknowledged that you had punted that question to those two witnesses, and that I would follow up later with them. And Mr. Chairman, that's all I had for Ms. Hill.
Great, thank you. Commissioners, any other questions? Okay. Mr. Huber, any redirect?
No, Mr. Chairman.
Thank you. Okay, thank you, Ms. Hip, for being here, and we appreciate your testimony, and you may step down.
Thank you.
Okay, we can move to the next witness.
ORS next calls Mr. Charles E. Loy.
Welcome, Mr. Loy. We'll make sure we can hear you. And operator, we've got Mr. Loy. Yes, sir. Good. If you'll raise your right hand, we'll swear you in. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Mr. Chairman.
Yes, sir, Mr. Huber.
Mr. Loy. Mr. Loy, would you please state your name and occupation?
My name is Charles Evans Loy. I'm a principal with the consulting firm of GDS and Associates, and I'm located in the Austin, Texas office, 919 Congress Avenue, Suite 1110.
Are you the same Charles E. Loy who pre-filed 20 pages of direct testimony in this case, dated May 26, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed direct testimony?
I do not.
If I ask you the same questions today, would your answers be the same?
Yes, they would.
Mr. Chairman, ORS asks that Mr. Loy's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Loy's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you. Mr. Loy, did you also prepare or cause to be prepared 7 exhibits labeled CEL1 through
CEL7, which were filed with the Commission as attachments to your pre-filed direct testimony.
Yes, I did.
Do you have any changes or corrections to your exhibits?
I do not.
Mr. Chairman, ORS asked that Mr. Loy's 7 exhibits labeled Exhibit CEL1 through Exhibit CEL7 be marked for identification and entered into the record of the case as the next composite hearing exhibit.
Mr. Loy's direct exhibit CEL 1 through 7 will be entered into the record as hearing exhibit number 17.
Thank you, Mr. Chairman. Mr. Loy, are you also the same Charles E. Loy who pre-filed 13 pages of surrebuttal testimony in this case on June 16th, 2020?
Yes, ma'am.
Do you have any changes or corrections to your pre-filed surrebuttal testimony?
I do not.
Mr. Chairman, ORS asked that Mr. Loy's surrebuttal testimony be entered into the record as if given orally from the stand.
Mr. Loy's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Loy, did you also prepare or cause to be prepared one exhibit labeled Surrebuttal Exhibit CEL1, which was filed with the Commission as an attachment to your pre-filed surrebuttal testimony?
Yes, I did.
Do you have any changes or corrections to that exhibit?
I do not.
Mr. Chairman, ORS asked that Mr. Loy's 1 exhibit labeled Surrebuttal Exhibit CEL1 be marked for identification and entered into the record of this case as the next composite hearing exhibit.
Mr. Loy's surrebuttal exhibit CEL1 will be entered as hearing exhibit number 18.
Thank you, Mr. Chairman. Mr. Loy is now available for questions from the parties and the Commission.
Thank you, Mr. Huber. Mr. Hall, any questions?
Yes, Mr. Chairman, thank you. Good afternoon, Mr. Loy. How are you?
Good afternoon.
Your testimony spends a considerable amount of time discussing CIAC and how it should be accounted for regarding the PY's $18 million acquisition of the city system, correct?
Yes.
And you also prepared a report documenting this issue as well, correct?
That's correct.
And that report, which has been commonly referred to as the GDS report, concludes that all but about $1.29 million of the net plant purchased was either donated or contributed to the city, correct?
That's correct.
And in your direct testimony, you also noted, however, with the exception of $1,536,501, a good deal of the remaining plant appears to be donated as evidenced by documentation provided in the acquisition case, correct?
That's correct.
In your testimony, you referenced 12 deeds that were included in the asset purchase agreement, is that correct?
Yes.
I'm going to attempt to share my screen, I think, one last time. Can you see this document?
Yes.
This has been previously entered as hearing exhibit 13. Is this the list of 12 deeds that you referenced in your testimony?
Yes.
And have you seen this chart before?
Yes.
Okay. And so following this document, which you testified to was included with the asset purchase agreement, I'm going to just kind of scroll through. There are numerous deeds as listed in that chart, correct?
That's correct.
And here, this first one, I'm not sure if everybody can read it. In the middle, it says it's Syntex Homes, conveying to the city of Columbia. Can you happen to see the purchase price there? The consideration?
Yeah, $1. Is that it? $1?
Yes, correct. And do you recall from the deeds that you reviewed, was that typical that whatever was conveyed to the city was for $1?
Yeah. Something, $1, $10, something like that, yeah.
Sure. And this is the next page of that deed. Not sure if you can read it once I blow it up. This is a description of the property. Can Can you read that?
Yeah, conveyance includes water booster pump. Oops, it disappeared. Water booster pump station, the sanitary sewer lift station, and part of it's cut off on the left there. Could you?
Let's see. Is that any better?
Click it one more time. Okay. The lift station, the on-site water lines, the on-site sanitary sewer lines, all easements shown therein, and the opportunities and fixtures associated therewith.
So this deed clearly establishes that the sanitary sewer lines were also provided to the city, correct?
Yes.
I'm just going to go through a couple more examples. Well, back to syntax was attached to the syntax. Do you agree this appears to be a plat of a neighborhood that was provided, that was part of the assets given to the city?
Yeah, it appears to be that, yes.
I will scroll back up so just see, this is page 12 of 32 of the exhibit, Fairways Development General Partnership. Again, much like the last one, it describes the conveyance. If you could read that highlighted portion for me.
Yeah, I can't read it. Okay. This conveyance also includes the existing sanitary sewer pump station with opportunities and fixtures attached thereto.
And would you agree that sewer lines are typically an appurtenance or a fixture to a sanitary sewer pump?
I would agree.
And we'll just look at one more for the sake of it. This is looks like it was from Richland County to the city. Not sure if you can read that highlighted portion or not.
Yeah. All those certain sanitary sewer lines and ports. Yeah, it's hard to see.
That's okay. Well, it's okay, but basically it does say that it includes the sanitary sewer lines, correct?
Yeah, it says, I can see including manholes, and manhole castings, service line connections, sanitary pumping station, yeah.
Okay. And so again, as you testified, the deeds, so I guess regarding your testimony, what is the relevance of these developer contributions in your calculations, or your determinations?
Well, basically, since they were donated, it's my understanding, or what I believe happened, is that the developers built the plant for their development, and then they gave it to the city. And that constitutes a donated plant or contribution in aid of construction. And as such, the city cannot record the liability, as I explained, but in the IOU world, that would be considered contributing capital that should not be allowed to earn a return on.
And it's correct, the PY's witnesses have said that the only donations were the lift stations, correct?
Yeah, that's my understanding.
And I believe you also testified that you've never encountered a situation in which a developer built a lift station and not the associated lines?
Yes, I've never encountered that, but not to say that it hadn't happened. I've never seen it.
And typically, if they were going to donate the lift stations, they would also donate the sewer lines.
It would make sense.
Yes. And I believe we've already kind of shown some of the plats, but I believe you also discussed the plats in your testimony as well.
Yeah, the plats were basically what Mr. Woods referred to, the as-built drawings. There were several hundred of them. So, it sounds like from his testimony that the city provided those to him.
Have you seen the as-built before?
Yeah, yes, I saw, there's like 700 or something of the flats. I looked at, probably 100 or so. I didn't look at all 700, but they all had developer names.
Thank you. I think, looking at your testimony, the next thing you discussed the city's accounting records. One of your exhibits. What's the relevance of the city's accounting records, in your opinion?
Well, it shows that when the city made when they recorded the sale, they removed the plant in which they built that they knew about, they had records for, but everything else they didn't have records for was not basically removed. They just recorded a profit and put that into equity. So basically it shows that there was no plant to offset the entire purchase price. So, it's easy to assume that it was most likely donated.
And did the city's accounting records include non-CIAC?
Yes, it did include non-CIAC, and it also included CIAC as well.
What's the significance of listing non-CIAC?
Well, it shows that that's plant that they purchased or they installed, and it's not contributed. It was never contributed, and so therefore it's it's allowable to be earned on from an IOU perspective.
And I believe you noted the city also recorded their gain on the transaction.
Yes, they did.
And what is the significance of that, in your opinion?
Well, the large gain just indicated they didn't have any plant to offset that gain. So my assumption was that the reason of the large gain is they had donated plant that was not recorded or they couldn't identify.
And we've heard other testimony that the sewer system shouldn't apply because it was not an operating unit or a system. I assume you disagree with that point as well?
Yes, I do.
That's all the questions I have.
Thank you, Mr. Hall. Commissioners, any questions for Mr. Loy? Mr. Belzer.
Chairman, Commissioner Hamilton.
Well, go ahead, Commissioner Hamilton.
Thank you, sir, Mr. Chairman. Happy to have you with us today, Mr. Loy.
Thank you, sir.
Mr. Loy, if the company were to adjust the values in the original cost study conducted by Tangible Group to reflect the use of Handy Whitman findings rather than CPIU, would you consider these to be reliable?
Yes, I would.
Okay, can you tell me the difference in your belief in Handy Whitman rather than CPIU, excuse me?
Yeah, well, Handy Whitman is specific to the utility industry. It's construction cost indices for utilities, and it's very widely accepted throughout the country for not only at commissions but also for a number of different things when estimating or projecting utility-related costs.
How about
on the other hand,
CPIU?
The CPIU is just a regular index, consumer price index that it doesn't have anything to do with utility construction costs. It's really more of consumer-related services and products that, say, most consumers use, like groceries or medical services, things like that.
So in your field, you wouldn't consider using cost price index for the utility?
Yes, not for valuing utility plant. So Handy Whitman is specific to utility plant. Now, the CPI could be used for other things like maybe inventories or electronics or, maybe transportation equipment, things like that. But when it comes to, plant that, provides utility service, Handy Whitman, in my belief, is the best index to use.
Thank you very much. I appreciate your testimony, sir.
Thank you,
Mr. Chairman.
Thank you, Commissioner Hamilton. Commissioner Belser.
Thank you, Mr. Chairman. Good afternoon, Mr. Loy.
Good afternoon.
Prior to your work with GDS Associates, I believe you were working in the regulated utility industry at some point in your career. Is that correct?
That's correct.
Okay. And I'm trying to get a handle on the valuation of this donated plant that Mr. Hall was asking you about. Since it was owned by a municipality, that we've heard earlier, the city is not required to use the same accounting uniform system of accounts that our regulated utilities are required to use. Is that a correct statement?
Yes, that's correct.
And if plant was donated to a regulated utility, it certainly qualifies as contributions in native construction, is it not?
Yes, that's correct.
And that doesn't mean that plant doesn't have value. Would that be a correct statement?
Yes.
But it does mean that the regulated utility would not be able to earn a return because the utility didn't make investment in that plant. Is that correct?
Yes, that's part of the reason. Yes.
So if a utility seeks to purchase, the example that we've got before us, plant from a non-regulated entity, just because something might be contributed, and if our regulated utility pays a fair market price for it, what should be the value that should go on the books of the regulated utility, even if there was contribution in native construction?
Yeah, right. This is a very tricky question because, you're correct that when a utility buys from a municipality, and depending on the regulations and their accountants, they may not be able to record CIAC, even though they may know it's donated, because they can't turn say equity into a liability when it comes from one entity to the other. And so really, the fact that it's donated has to be divulged by the utility and if known, and it has to be booked according to the commission rules.
But
so,
no, don't let me interrupt. Go ahead.
No, go ahead. I'm
well, I mean, if the plant is donated to the non-regulated entity, and that plant is going to have value, and then for whatever reason that non-regulated entity decides to sell and it's being purchased by a regulated entity, as long as I reckon my thinking is, as long as the regulated entity pays a fair value, not overpaying, not overpaying for what is actually there, that is their investment for which they should be able to earn a return under Hope, Bluefield, and other other regulatory maxims.
Well, in this case, it's the ORS's position that if that was allowed to happen, let's say if they were to if they paid for the CIAC, or they paid the municipality for the donated plant, and they moved it over to rate base, and they started earning on it, then basically the ratepayer would end up paying twice. And that's because it's assumed that when the ratepayer bought their home from the developer, that the price of that home included the cost of the utility, of the collection system and the lift stations, okay? So basically how a developer works, they don't act like a utility. They don't invest in the plant and then put them on the books and then hand them to the municipality or the utility. What they do is they inventory all the plant that they spend, all the money they spend on the plant, and they expense it. And so in many instances, at least I've known that developers will turn over plant and they really won't know the
Commissioner
value.
Belzer.
Yes, sir, Mr.
I apologize for interrupting. ORS was cut off the phone line a few minutes ago, and we have not been able to hear any of the testimony. But we heard, was there a second question? Your second question and Chuck's answer, but then we were cut off.
Okay.
Sorry, Mr. Lloyd's answer, excuse me.
What do we do? No, I don't remember what I asked. We were having a conversation more than a question and answer, I thought.
Right.
Ms. Wheat, let me check with Ms. Wheat.
Could the, sorry, I had a suggestion. Could the court reporter read back what was said and we...
Just a moment, Mr. Huber. We're checking with the court reporter.
We think we're going to be able to get that read back, Mr. Huber.
Thank you.
Ms. Wheat has not had to do a read back in a long time, but we're going to give her her moment in the sun.
Have we lost Mr. Hall?
I'm here.
Okay.
He's there. Did anybody else lose this except ORS? Okay.
The applicant could hear everything.
Okay.
As could Consumer Affairs.
Okay.
Thank you, though. Okay. Since it was owned by municipalities, we've heard earlier, the city is not required to use the same accounting, the uniform system of accounts that regulated utilities are required to use. Is that a correct statement? Answer, yes, that's correct. Question. And if plant was donated to a regulated utility, it certainly qualifies as contributions in aid of construction, does it not? Answer, yes, that's correct. Question, and that doesn't mean that that plant doesn't have value. Would that be a correct statement? Answer, yes. Question, but it does mean that the regulated utility would not be able to earn a return because the utility didn't make an investment in that plant. Is that correct? Answer, yes, that's part of the reason, yes.
We were cut off.
Question, so if a
we heard that
utility
piece.
seeks to purchase, the example that we've got before us, plant before a non-regulated entity, just because something might be contributed, and if a regulated utility pays a fair market price for it, what should be the value that should go on the books of the regulated utility? Even if there were a contribution in aid of construction. Answer, yeah, this is a very tricky question. And yeah, you are correct. When a utility buys from a municipality, and depending on the regulation, and their accountants, they may not be able to record CIAC, even though they may know it's donated, because they can't turn a safe equity into a liability when it comes from one entity to another. So really, the fact that it's donated has to be divulged by the utility, and so it's known, and it has to be booked according to the commission rules. There's a bit of an interruption. Question. Well, I mean, if the plant is donated to the non-regulated entity, and that plant is going to have value. Answer, right. Question, and then for whatever reason that non-regulated entity decides to sell, and it's being purchased by a regulated entity, as long as the value, I reckon my thinking is overpaying for what is actually there. That is their investment for which they should be able to earn a return under HOPE, Bluefield, and other type of regulatory maxims. Answer. Well, in this case, it's the ORS's position that if that was allowed to happen, let's say if they were to earn, if they paid for the CIAC, they paid the municipality for the donated plant, and they moved it over to the rate base and started earning money, then basically the ratepayer would end up paying twice. And that's because it's assumed that when the ratepayer bought their home from the developer, that the price of that home included the cost of the utility, of the collection system and lift stations, okay? So basically how a developer works, they don't act like a utility. They don't invest in the plant and put them on the books and then hand them to the municipality or the utility. What they do is they inventory all the plant and all the money they spend on the plant and expense it. They expense it. So in many instances, the developers will turn over plant and they don't really know. And that catches it up.
Okay, and that's, I think, have you got all that, Mr. Huber?
I did, Mr. Chairman. Thank you and thank you, Ms. Wheat, for reading that back to us.
Thank you, Ms. Wheat. Okay, I guess Commissioner Belser, did we break your train of thought?
Oh, yeah. Mr. Loy, had you finished your response?
Yes.
Do you need to add anything?
No, I think I covered it. I think I said what I needed to say.
So, are you telling me that anytime we go from a non-regulated that a regulated entity purchases plant from a non-regulated, that the CIAC, any donated plant, any CIAC will not have any value on the regulated utilities books?
Yeah, that's the general consensus, I believe, is that the accounting, how things were accounted by a nonprofit or a city, how the CIAC was accounted, it doesn't change the nature of the fact of the matter that the plant was donated. Okay? Counting doesn't matter.
Well, under that line of thinking, how could there ever be a change of plant to a regulated entity? I mean, if somebody, and
right.
if somebody is making a fair, I'm just thinking from a practical standpoint, if somebody's making a fair investment or an investment at a fair price, why would they do that if they can't earn a return on that investment, which is allowed?
I understand.
Go ahead.
And that's what, yeah, I'm sorry, Commissioner.
No, we're fine.
And that's what makes this case so unique is, there's, and I believe I talk about this in my report, is that, we see more and more of this where municipalities sell to IOUs. And it's typical that the municipality is, kind of in over their head. They can't get the financing. They kind of like to let things go. But IOUs have always been hesitant to do this purchase because of the CIAC donated plant, grants, funded by the utility, right? The utility owner, so to speak, quote unquote. And so where this has been successful, this transfer from public to private, has been in states that have special legislation, like I know Pennsylvania was really where it started, and now in Texas, and there's California. I think there's 3 or 4 other states, but basically what this legislation does is it allows the commission to value the plant fairly, but not consider the source of funding. The source of funding cannot be considered. So whether the plant was grants, was it donated by developers, or was it financed by ratepayer debt, that can't be considered. And so this is one way of getting around it. So it is a problem, and that's why, in my report, I cautioned the ORS to proceed, with caution, so to speak. So.
Mr. Loy, thank you very much. Appreciate your testimony today. That's all I have, Mr. Chairman.
Thank you. Commissioners, any other questions? Okay, any redirect, Mr.
Chairman.
Huber? Yes. Who was that? I couldn't hear you.
Mr. Chairman, that was me, Whitfield.
Okay, Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Loy, want to kind of give you a crack at a question that I asked Ms. Hipp. She kind of punted to witnesses Cleckley and Sullivan, but you also made a reference to GDS, so maybe you can take a stab at it, and we won't have to go there with the other witnesses.
Okay.
I don't know if you heard it. Was the question I had to repeat when we went offline there for a little while. Did you hear that?
Yes.
Do you need me to repeat the question, or do you want to take a stab at it, or I can repeat it to you?
Let me take a stab at it. I think if you go to my testimony, page 13, and look at table 3, you'll see where it came from. And just tell me when you're there.
Okay.
So on the far left-hand column under company, that's the plant valued using the CPI, the PRC plant that the company had in rate base, requested in rate base, using the CPIU. And the second column is the plant that GDS came up with using the Handy-Whitman indices. And the delta is the far right column.
Okay. Thank you, Mr. Lloyd. Just one more question, if I could, for you. I want to refer to your testimony now, and on page 17 of your direct testimony.
Yes.
You state that the PRC plant clearly constitutes a system. Would you explain the reasoning behind that statement?
Well, it consists of a collection main that runs through a subdivision or a group of subdivisions, and there are service connections to that collection main, and there's also lift stations to move the waste toward the treatment plant or the transmission line. In addition, it's when the company filed their APA, they referred to it as a system. This commission referred to it as a system, and so I believe it's a system.
Thank you, Mr. Lloyd. That's all I have, Mr. Chairman.
Mr. Chairman, Commissioner Hamilton.
Yes, sir, Commissioner Hamilton.
Yes, sir. I'd like to ask Mr. Lloyd one more question, if I could, sir.
Yes, sir.
Mr. Lloyd, what type of value would be placed on a company receiving approximately 1,000 plus monopoly customers?
That's a pretty open-ended question, Commissioner. I guess what they would look at is the cash flow that the monopoly customers provided and the expenses to operate it, and they would do some sort of valuation from the net cash flow of that.
Thank you, sir, very much. Thank you, Mr. Chairman.
Thank you, Commissioner Hamilton. Okay, now back to Mr. Huber. I think we were asking for any redirect.
No redirect, Mr. Chairman, and we would ask that Mr. Lloyd be excused.
Thank you. Mr. Lloyd, thank you so much for your testimony and for being here, and you may step down and you are excused.
Thank you, sir.
ORS calls its next witness, Dan Hennell. Daniel P. Hennell II.
Okay, Mr. Hennell, if we can get you to raise your right hand, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Hennell, would you please state your name and occupation?
My name is Daniel P. Hunnell II. I'm employed by the Office of Regulatory Staff as a senior regulatory analyst.
And are you the same Daniel P. Hunnell who pre-filed 26 pages of revised direct testimony in this case?
Yes, I am.
Which was dated June 5th, 2020, the unredacted version of which was filed on July 8th, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed revised direct testimony?
Yes.
Are those changes or corrections listed on an errata sheet filed on July 6th, 2020?
Yes,
Can you walk us through those changes?
I can. The first one would be on page 16 of 26, line 23. Please add the word amended before application and strike the word Exhibit A. Page 17 of 26, line 1. Strike the words page 6 of 6 and replace with page 7. Page 17 of 26, lines 3 and 4. Strike the words, the company should be required to file a corrected application Exhibit A to reflect the correct commission regulation. Page 21 of 26, line 21. Please strike the word rule and replace with instruction. Page 24 of 26, line 6. Strike the amount $2,001,430 and replace with $2,032,146. Page 24 of 26, line 16. Strike the amount $2,001,430 and replace with $2,032,146. Page 24 of 26, line 22. Strike the amount $2,001,430 and replace with $2,032,146. Page 25 of 26, line 12. Strike the amount $1.62 and replace with $1.65. And the last one is page 25 of 26, line 12. Please strike the calculation $2,001,430 divided by 34,290 ERCs divided by 36 months and replace with $2,032,146 divided by 34,290 ERCs divided by 36 months.
And if I ask you the same questions today, would your answers be the same?
Yes, aside from the changes I just read.
Mr. Chairman, ORS asked that Mr. Hunnell's revised direct testimony, the unredacted version of which was filed on July 8, 2020, with the corrections indicated in the errata sheet, be entered into the record as if given orally from the stand. And ORS also requests the errata sheet be attached to his testimony.
Okay, Mr. Hunnell's pre-filed revised direct testimony with the corrections that were listed on the errata sheet will be entered into the record as though given orally from the stand, and the errata sheet will be attached to the testimony.
Thank you, Mr. Chairman. Mr. Hunnell, did you also prepare or cause to be prepared 11 exhibits labeled Revised Exhibit DPH-1 through Revised Exhibit DPH-11, which were filed with the Commission as attachments to your pre-filed direct testimony?
Yes, I did.
Do you have any changes or corrections to revised exhibits?
No, I do not.
Mr. Chairman, ORS asked that witness Hunnell's 11 exhibits labeled Revised Exhibit DPH-1 through Revised Exhibit DPH-11 filed on July 8, 2020, be marked for identification and entered into the record of the case as the next composite hearing exhibit.
Mr. Hunnell's pre-filed direct revised exhibits DPH-1 through DPH-11 will be entered as exhibit number 19.
Thank you, Mr. Chairman. Mr. Hunnell, Are you also the same Daniel P. Hunnell II who pre-filed 15 pages of sir rebuttal testimony in this case on June 16th, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed sir rebuttal testimony?
I do not.
Mr. Chairman, ORS asks that Mr. Hunnell's pre-filed sir rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Hunnell's pre-filed sir rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Mr. Hunnell is available for questions from the parties or the commission.
Okay. Mr. Hall.
No questions. Thank you.
Thank you. Commissioners. Any questions of Mr. Hunnell?
Mr. Chairman. Mr.
Yes,
Chairman.
sir. Mr. Howard.
Mr. Hunnell, using a 5-year average, you recommended a bad debt expense of 1.78%.
Commissioner Howard, we can't hear you. You need to get into your phone a little bit closer.
Is that better?
Yes, sir. Much better.
Is that better? Thank you. I'll start over. Using a 5-year average, you recommended a bad debt expense of 1.78%. This is a 72-point decrease over the 2.5 that they've been authorized. Mr. Daddy contends that a 2.3 would be a better average using a 3-year average over your 5-year average. Do you have a preference of using a 5 or a 3-year average and calculating bad debt expense?
I have historically used a 5-year average, and Mr. Gaudet in his testimony does indicate that he did experience a 2.3% bad debt percentage, yet he did not provide any data for me to be able to validate that amount. In fact, I was unable to duplicate that amount.
Let me ask you a hypothetical. I talked to Mr. Daddy about the current pandemic, and he said there was going to be a tremendous increase in bad debt because of the deferred payment plan and that's got the deferred payments of. What are your thoughts on how would you accounting treatment of a pandemic effect on a one-time thing such as the bad debt expense?
Well, right now, it's not known and measurable what effect the COVID-19 emergency will have on this company's bad debt expense. So that would be purely speculation on my part.
Any kind of accounting method that would account for that? Maybe just a short-term method or a short-term spike or something like that?
Not that I have ever seen, no, sir.
Thank you very much. Thank you, Mr. Chairman.
Thank you, Commissioner Howard. Commissioners, any other questions?
Chairman, Mr. Hamilton.
Yes, sir, Commissioner Hamilton.
How are you today, Mr. Hummel?
Good. How about yourself, sir?
Fine. Is this your first time before the PSC?
It is my first time between the South Carolina PSC, yes, sir.
Thank you. Welcome home. Mr. Hummel, if I'm correct, your testimony accounts for an increase to late fees after a performing revenue requirement adjustments, but does not address how you computed the late fees. Could you give us an example of how late fees are?
I did not actually calculate the late fees. I calculated the percentage of late fees that was used by the OS audit department to make that adjustment.
All right. Thank you, sir, very much, and happy to have you with ORS.
You're welcome, and thank you.
Thank you, Commissioner Hamilton. Commissioners, any other questions? Mr. Hunnell. Okay, any redirect?
No redirect, Mr. Chairman.
Okay, thank you. Mr. Hunnell, thank you for your testimony. Appreciate you being here, and you may step down.
Thank you, sir.
And Mr. Chairman, I'd appreciate if you bear with us for a few moments while we switch out witnesses. ORS will next call William C. Cleckley to the stand.
Okay, and while we're switching out, we're going to take about a 5 to 7 minute break, and then we will be back.
Thank you.
Thank you. Welcome back. Everyone, we'll do a quick roll call of commissioners, and then we will continue. Vice Chair Belser.
Present.
Commissioner Whitfield.
Here.
Commissioner Hamilton.
Here.
Commissioner Howard.
Here.
Commissioner Irvin.
Here.
Okay, thanks. Everybody is here, so we will go. Mr. Huber, it's your next witness.
Thank you, Mr. Chairman. Jenny Pittman for ORS. At this time, ORS would like to call William Cluckley to the stand.
Okay, Mr. Cluckley, if you will please raise your right hand, and we will get you sworn in. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, Ms. Pittman.
Mr. Cluckley? No, thank you. Mr. Cluckley, can you please state your name and by whom you're employed and in what capacity?
My name is William C. Cleckley. I'm employed by the South Carolina Office of Regulatory Staff as an auditor.
Are you the same William Cluckley who pre-filed 9 pages of direct testimony in this case on May 26, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed direct testimony?
No, I do not.
If I ask you the same questions here today, would your answers be the same?
Yes.
Mr. Chairman, ORS asks that the pre-filed direct testimony of Mr. Cluckley be read into the record as if given orally from the stand.
Mr. Cluckley's pre-filed direct testimony will be read into the record as though given orally from the stand.
Thank you. Mr. Cluckley is available for cross-examination and questions from the commission.
Thank you. Mr. Hall.
No questions, thank you.
Thank you. Commissioners, any questions for Mr. Cluckley? Hearing none, Mr. Cluckley, you seem to have gotten off easy here. So we appreciate you being here and appearing for a minute, and you may step down.
Thank you, sir.
Thank you, Mr. Chairman. At this time, ORS will call Daniel Sullivan to the stand.
Okay, as soon as we get Mr. Sullivan up there, we'll swear him in. There he is. Welcome, Mr. Sullivan. If you will raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Sullivan, would you please state your name and occupation?
Daniel Sullivan. I'm employed by the South Carolina Office of Regulatory Staff as the Deputy Director of the Audit Department.
Are you the same Daniel Sullivan who pre-filed 11 pages of revised direct testimony in this case on June 5th, 2020?
Yes, I am.
Do you have any changes or corrections to your pre-filed revised direct testimony?
Yes, I do.
Are those changes or corrections listed on an errata sheet that was filed on July 6th, 2020?
Yes, they are.
Can you walk us through those changes?
Sure. Page 8 of 11, line 15, please strike the amount of $2,001,430 and replace with $2,032,146. Page 8 of 11, line 16, please strike the amount negative $2,001,430 and replace with negative $2,032,146. Same page, 8 of 11, line 18. Please strike the date August 7th, 2020, and replace with August 21st, 2020.
If I ask you the same questions today, would your answers be the same?
Yes, aside from the changes I just mentioned.
Mr. Chairman, ORS asks that Mr. Sullivan's revised direct testimony with the corrections as indicated be entered into the record as if given orally from the stand.
Mr.
Along
Sullivan's.
with the errata sheet.
Yes, ma'am. Mr. Sullivan's pre-filed revised direct testimony will be entered into the record as though given orally from the stand with the corrections on the errata sheet, and the errata sheet will be attached to his testimony.
Thank you. Mr. Sullivan, did you also prepare or cause to be prepared two exhibits labeled Revised Exhibit DFS-1, which was filed with the Commission as an attachment to your pre-filed revised direct testimony, and a second Revised Exhibit DFS-2, which was filed on July 6, 2020?
Yes.
Do you have any changes or corrections to your Revised Exhibit DFS-1 or your second Revised Exhibit DFS-2?
No, I do not.
Mr. Chairman, ORS asks that witness Sullivan's two exhibits labeled Revised Exhibit DFS-1 and Second Revised Exhibit DFS-2 be marked for identification and entered into the record as the next composite hearing exhibit.
Thank you. Mr. Sullivan's pre-filed direct revised exhibit DFS-1 and second revised exhibit DFS-2 will be entered as composite exhibit number 20.
Thank you. Mr. Sullivan, are you also the same Daniel Sullivan who pre-filed 13 pages of surrebuttal testimony in this case on June 16, 2020?
Yes.
Do you have any changes or corrections to your pre-filed surrebuttal testimony?
Yes, I do.
Are those changes or corrections listed on an errata sheet that was filed on July 6, 2020?
Yes, they are.
Can you walk us through those changes?
Sure. Page 4 of 13, line 1, please strike the date August 6, 2020, and replace with August 20, 2020. Page 7 of 13, line 17, please strike the amount negative $2,001,430 and replace with negative $2,032,146.
If I ask you the same questions today, would your answers be the same?
Yes, aside from the changes I just mentioned.
Mr. Chairman, ORS asks that Mr. Sullivan's surrebuttal testimony with the corrections as indicated be entered into the record as if given orally from the stand, along with the errata sheet.
Mr. Sullivan's pre-filed surrebuttal testimony with the corrections will be entered into the record as though given orally from the stand, and the errata sheet will be attached to his testimony.
Thank you. Mr. Sullivan, are you also adopting the direct testimony and exhibits of Christina L. Seal in this case?
Yes.
Mr. Chairman, Hearing Officer Directive Order number 2020-53H granted ORS's request to permit Mr. Sullivan to adopt the testimony of Christina L. Seal. Therefore, Mr. Sullivan is prepared to be cross-examined by other parties and answer any commissioner questions regarding Ms. Seal's testimony and exhibits.
Okay, thank you.
Mr. Sullivan, did Ms. Seal pre-file 18 pages of direct testimony in this case on May 26, 2020?
Yes.
Are there any changes or corrections to Ms. Seal's direct testimony?
No.
Mr. Chairman, ORS asks that Ms. Seal's direct testimony be entered into the record as if given orally from the stand.
Ms. Seal's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Thank you. Mr. Sullivan, did Ms. Seal also prepare or cause to be prepared 7 exhibits labeled Exhibit CLS-1 through Exhibit CLS-7, which were filed with the Commission as attachments to Ms. Seal's direct testimony?
Yes.
Are there any changes or corrections to Ms. Seal's exhibits?
No.
Mr. Chairman, ORS asks that Ms. Seal's 7 exhibits labeled CLS-1 through CLS-7 be marked for identification and entered into the record as the next composite hearing exhibit.
Ms. Seal's pre-filed direct exhibit CLS-1 through CLS-7 will be entered into or be entered as exhibit number 21.
Thank you. Mr. Sullivan is available to answer any questions from the consumer advocate or the commissioners.
Thank you. Mr. Hall.
No questions.
Thank you. Commissioners, questions of Mr. Sullivan? Okay, hearing none. Mr. Sullivan, thank you for being here, and
thank you.
You may step down.
Thank you, Mr. Chairman. That's all from ORS.
Thank you, Ms. Pittman. Okay, I think we have heard from all of our witnesses. Let's see, I think the one thing we need to do is, Mr. Butler, if you will make sure we're all on the same page as far as our exhibits go.
Yes, sir, I'll be glad to do that. And we'll go ahead and start with exhibit number 1, which was a sign-in sheets for the virtual Columbia night hearing from March 19th, 2020. Exhibit number 2, sign-in sheets from the virtual Columbia night hearing of June 22nd, 2020. With regard to the merits hearing, exhibit number 3 is the stipulations entered into by and between Palmetto Utilities and the Office of Regulatory Staff. Exhibit 4 is Ms. Powell Baker's pre-filed direct exhibits APB 1 and 2. Exhibit 5 is Mr. Daday's pre-filed direct exhibits 1 through 4. Exhibit number 6 is pre-filed Mr. Daday's rebuttal exhibits 1 through 8. Exhibit 7 is a late filed exhibit that was requested by Commissioner Belser on capital expenditures. Exhibit 8, pre-filed direct exhibit A of Mr. Joel Wood. Exhibit 9, Donald J. Clayton's pre-filed direct exhibits, DJC exhibits 1 through 3. Exhibit number 10, Mr. Gary Walsh's pre-filed rebuttal exhibits 1 through 6. Exhibit number 11 is Mr. Harold Walker's pre-filed direct exhibits HW1 and 2. Exhibit number 12 is Mr. Walker's pre-filed exhibit, rebuttal exhibit number 1. Then we had exhibit 13, which was the attachment J and schedule 3.1F from the asset purchase agreement that was entered into the record. Exhibit 14 is Mr. Aaron Rothschild's pre-filed direct exhibits ALR 1 through 7. Exhibit 15, Mr. David Parcells pre-filed direct exhibits DCP 1 and 2. Exhibit 16 was Ms. Dawn Hipp's pre-filed surrebuttal exhibits DMH 1 and 2, 3, and revised exhibit DMH 4. Exhibit 17 was Mr. Charles Loy's pre-filed direct exhibits CEL 1 through 7. Exhibit number 18, pre-filed surrebuttal exhibits of Mr. Loy. It's exhibit CEL 1. Exhibit number 19 is Mr. Hanel's pre-filed direct exhibits DPH 1 through 11. Exhibit number 20 is Mr. Daniel Sullivan's pre-filed direct revised exhibit DFS number 1 and second revised exhibit DFS number 2. And the final exhibit's Ms. Seals pre-filed direct exhibit CLS 1 through 7. And Mr. Chairman, that completes the list of exhibits that I have.
Great, thank you. And I know you have already spoken about proposed orders, so I'll let you go ahead and do that, please.
Oh, yes, sir. We had discussed, and it appeared in one of my hearing officer directives, that the proposed order date will be July 29th, 2020. Thank you, sir.
Thank you, and that's everybody's on board with the July 29th, 2020.
Yes, Mr. Chairman.
Thank you, thank you.
Yes, Mr. Chairman.
Thank you. Okay, anything else to come before us from anyone? If not, thank you everyone for your patience with this virtual hearing, for hanging in there when we lost a few of you a few times, and thank Ms. Wheat for getting to take center stage and do a little reading as well. And with that, we are adjourned.